Good morning. Hello, everyone. I would like to thank all of you for being here today. I'm on all the events and academic activities I am involved in this intergenerational arbitration symposium, or IGAS with an Italian accent, as Franco and I call it, is perhaps the one I like the most. And this IGAS was conceived some years ago, close to this very place, in a coffee shop, when my dear friend, Professor Franco Ferrari, we were wondering for a particular way, a different way to support our former students and brilliant young people in the field of international arbitration in general. And the idea was, the idea was emerged at that time, was to confront them, those young people, with more experienced people, academics and practitioners, around relevant and controversial topics of international arbitration. And I must say that the result of at least the two first editions we have of IGAS was really amazing. The more experienced debaters, I will try to avoid the old ones, were really impressed of the level of the proposals of the young ones. And for example, last year, one of the experienced debaters was Professor Pierre Tercier, who's a well-known professor and with, I don't know, hundreds of arbitrations behind. And he told me at the end was, well, actually, I didn't feel as a professor and student, it's just more or less experienced specialist. And he was really making advertising of this experience everywhere after his participation in the second IGAS in Paris. And I think that there are two or three key factors to make this successful and really something that it would be made. The first one is the selection of the young, and that is, I think, always very good, and we will be seeing today that today is the same thing. We have selected excellent young practitioners and scholars who are already really in depth in international arbitration, and we know perfectly the topics that they will discuss with us. The second one is the environment, the ambience we can give to these events, and that is made in a part for the selection of the debaters and moderators, and also because of the wonderful spirit of my colleague, Professor Ferrari, who always do many things and everything very well. And the third one is the selection of the topics. And for today, if you look at the topics, or the topics are really controversial, they are really hot topics in international arbitration, matters that are not settled. And so we have a big room to discuss on them, and perhaps to suggest some answers to those ideas that are struggling both arbitral tribunals and local courts, when they must decide about corruption or about this kind of evidence that is gathered in a non-orthodox way, or matters well known but we are not settled yet as interim measures or privilege. So I am very happy to be here once again. Thank you, Franco. Thank you, all of you, for being here. And I give the floor to the first moderator, Sarah Ciokieski.
Thank you very much, Professor Fernandez Arroyo, and thank you, Professor Ferrari, for this kind of invitation to be here. It's a real pleasure to introduce our first panel and our honored panelists to discuss the use of evidence gathered in non-traditional ways. Now, this seems to be a slightly mysterious topic to me. But if we think about it, it is particularly a relevant one today. Hardly a day goes by without a conversation, news article, or LinkedIn feed, as you've been probably bombarded by it, that discuss the new technological tools that are transforming the way that we relate to our world. So we've heard a lot: ChatGPT, generative AI, blockchain, Web3, and of course, the cybersecurity and legality issues that come with it. So as these tools become more and more widespread, inevitably they'll find their way in our courts and arbitration hearings. These, of course, raises lots of issues and questions about due process, efficiency, preservation of the right of the parties, all those things that our panelists will talk about today. So Clara Kalbach and Bruno Sousa Rodriguez, whom we've had the pleasure to welcome, have authored two very interesting papers on these issues, which we'll present to you in just a moment. Leaked to us from WikiLeaks to international arbitration, developing a new framework to determine the admissibility of illegally obtained evidence in international arbitration, and the use of detectives in international arbitration. What limits? So Clara is an alumna from both Sciences Po and NYU Law, where she specialized in international business regulation, litigation, and arbitration. She trained in Paris in commercial litigation and arbitration in Latham & Watkins and Denier-Pique. And she's now an associate at a boutique law firm in New York, and she practices arbitration, commercial litigation, and international asset recovery. Bruno is a lecturer and researcher at Sciences Po Law School. He holds a PhD from the same institution. His scholarly interests gravitate around international arbitration, public and private international law, transnational legal theory, and legal sociology. Bruno is also an attorney admitted to the Brazilian bar who regularly acts as tribunal secretary in international arbitrations. Now, we're also very lucky to have with us Louis Benno Kimmelman, who will be providing a commentary to Bruno and Clara's research papers from the perspective of an international arbitrator, but also as an experienced counsel. As you may already know, Bruno is an international arbitrator based in New York, a professor at Brooklyn Law School, and chair of the New York International Arbitration Center. Before that, Benno was a partner at Sidley Austin, and he was co-leading Sidley's global international arbitration practice. Now, this presentation will be organized. First, each presenter will have 10 minutes to discuss about the topics. We'll have a 15-minute critique, and then the floor is open to question and an open discussion. So we do welcome questions from the audience. One last thing, this session will be recorded, and a video link will be made available by Professor Franco Ferrari. And we have a lot to cover, so without further ado, I leave you the floor.
Thank you so much for the introduction. Can you all hear me properly? Perfect. So I'll be starting the day by talking about illegally obtained evidence in arbitration. And before I dive into the topic, I would just like to point out that all the documents and material that I used in making this presentation were obtained legally and with clean hands. So more seriously, illegally obtained evidence in arbitration, or does the end sometime justify the means? Leaked to us was the very catchy message featured on the webpage of the International Consortium for Investigative Journalism, prompting visitors to share information with them. The consortium is a US-based organization that is responsible for major investigative reportings, including the Panama Papers. Similarly, in 2006, around 250,000 confidential diplomatic wires were released and published on the WikiLeaks website, which is a self-described media organization seeking to make information available to the general public without directly benefiting from it. Large-scale data leaks, as well as the increased number and frequency of hacking, cyber intrusions, and security breaches, truly have changed the face of evidence forever. And the availability of data on platforms similar to WikiLeaks has impacted parties to legal proceedings, but obviously ultimately parties to international arbitrations. And this makes the issue of illegally obtained evidence an increasingly relevant topic and a very important issue to look at in arbitration today. So how do arbitrators deal with the admissibility of illegally obtained evidence? Two very important factors should first of all be highlighted when we talk about that topic. The first one is the very broad discretion that is granted to arbitral tribunals when dealing with the admissibility of evidence more generally, but also with illegally obtained evidence. And the second one is the absence of a general exclusionary rule that would simply lead to the exclusion of evidence on the basis that it has been illegally obtained. So what should we do? There are different ways to look at the issue. The first one could be simply to resort to the lex arbitri and refer to these principles to determine the admissibility of the evidence. But another way that has been highlighted by different authors and that we will be dealing with today is to refer to general principles to determine the admissibility of illegally obtained evidence in arbitration. So in this presentation, I will, in the first part, deal with and expose to you the current framework that we're working with, and in the second part, I will expose ways in which we can further develop and enhance the current framework to deal with illegally obtained evidence in arbitration. So first of all, the current situation, which is marked by both the absence of a clear evidentiary framework to deal with evidence and illegally obtained evidence, and a proposed three-part test. The absence of a unique evidentiary scheme to deal with illegally obtained evidence is very well illustrated by the different relevant provisions. I can, for example, point to the UNCITRAL model law and its Article 92 that provides that the power conferred upon the arbitral tribunal includes the power to determine the admissibility, relevance, materiality, and weight of any evidence offered. And these are almost the same terms used in the UNCITRAL arbitration rules in their Article 27.4. The IBA rules on the taking of evidence in arbitration, which is also very often referred to, also provides for significant leeway in dealing with the admissibility, relevance, materiality, and weight of the evidence offered by the parties. So in light of this initial very broad discretionary framework, two authors in 2018, Sherry Blair and Emma Vida-Goshkovich, provided with a paper in which they detailed a three-part test to deal with illegally obtained evidence and to help guide arbitrators in making their decision. And their test is framed around three questions. The first one is, has the evidence been obtained unlawfully by the very party seeking to benefit from it? And this is a way to ensure the respect of good faith in arbitration. The second question is, do the public interests favor the rejection of the wrongfully disclosed documents? And the second question was framed more specifically as a way to include considerations of confidentiality, diplomatic immunity, or even privilege. And in doing so, the authors refer to specific cases. They refer to the Karatube case, in which one party was trying to introduce evidence that was found on the KazakhlEaks website and that the parties were trying to rely on, and the arbitrator actually included the evidence because it considered that the documents were neither privileged nor confidential. However, in another case in Libanenko, the parties similarly tried to rely on evidence that was obtained through hacking. However, the evidence was not placed on a third-party website, and in that case, the tribunal found that the evidence should be excluded because it was privileged and confidential. And you can also see by the way that I described these two cases that it also refers to the very first element, which is the party's involvement in the obtention of the evidence itself. And then the third question of this first framework was, do the interest of justice favor the admissibility of the wrongfully disclosed document? And this was sort of a more general way to provide a balancing test to determine the admissibility of such evidence. So now, in my second part, I will be talking about ways in which we can further develop and enhance this framework in order to provide even more efficiency and predictability in international arbitration. As I've highlighted throughout this presentation and this first part many times, arbitrators are granted a very broad discretion when dealing with the admissibility of evidence generally, but also illegally obtained evidence. And all the decisions and provisions that I pointed to actually provide very little to no guidance as to how they should be dealing with that evidence. And so in light of that, it is very important to consider the fact that the lines have become increasingly blurred in light of new technologies and these developments, and therefore proving the need for a very efficient and developed framework dealing with the admissibility of evidence. And so this proposal is really focused on two main considerations, which are the way in which the evidence was obtained, as well as the probative value of the evidence itself. And rather than framing the test around three questions, which was done before, it is focusing on the main goals and objectives of international arbitration, as well as the duties of arbitral tribunals. And to do so, I will detail three elements that are absolutely fundamental. The first one is the promotion of good faith in international arbitration. And this is mainly a confirmation of the first model and the first criterion. Through the clean hands doctrine, making sure that the party seeking to introduce the evidence was not involved in obtaining the evidence unlawfully. And the third disinterested party requirement, which is a way to ensure that the party who was possibly involved in obtaining the evidence is neither a party to the proceedings, but also does not stand to gain or lose anything from the outcome of the arbitration. And this is a criterion that has been very often used by arbitral tribunals in practice. In the Methanex case, for example, one party was trying to introduce evidence that was obtained through dumpster diving, thus quite literally getting its hands dirty in the obtention of the evidence, and the arbitrator actually rejected that evidence, finding that it was obtained through unclean hands. This first criterion, that is the good faith criterion, could also very well be used not only in analyzing the party's good faith in obtaining the evidence, but also in the party's good faith in trying to introduce the evidence in the proceedings. Then the second element of this updated framework is an analysis of the evidence's relevance and materiality. And although this was not included in the original framework, it is an amazing way to provide more efficiency in arbitration and has actually been referred to by arbitral tribunals. In Methanex, not only did the tribunal find that the party had unclean hands, it also found that the party was actually trying to introduce evidence that was completely irrelevant to the case that was being made by the very same party. The second element is, the third element, is the preservation of the integrity of the arbitration proceedings. And I will conclude my presentation with this. This final element is a third and additional consideration that can be taken into account by arbitral tribunals to look at potential issues of privilege, confidentiality, or even generally public interest to mainly ensure that the parties are granted some form of equality of arms in presenting their argument, and that each party in international arbitration is granted an equal opportunity to present their case. And I will stop there.
Well, thank you very much. I will try to mark my time as well. Thank you very much for being here today. Before I start, I would like to thank Professor Diego Fernandes Arroyo and Professor Franco Ferrari for the invitation. Is it working? Oh. I will have my 30 seconds back. Sorry. Thank you very much, Professors Ferrari and Fernandes Arroyo, for the invitation. It's a pleasure to be here today. My topic is the use of detective in international arbitration, but I wish to focus more specifically on one dimension of this topic, which is the increasing involvement of so-called private intelligence agencies and the deployment of private covert operations in international arbitration. We're going to understand what this is. Maybe not all of you are aware of the problem. But I wish first to maybe engage in an exercise of imagination. Imagine one day you wake up, you are in your apartment, you wake up in the morning, take a cup of coffee, you look at the window, and then you realize there are two people very creepily staring at your apartment taking pictures. Another day you walk around the street, you realize you're being followed. Then you suspect that your phone is acting weird. Perhaps someone hacked your phone. They are now in possession of your GPS information. You start receiving very weird emails from unknown sources, trying to schedule meetings. You realize some of these people are actually using false identities. None of these examples are taken from a bad thriller. Rather, they are taken from real-life examples that took place in the Weinstein case. So Harvey Weinstein had hired a private intelligence agency, namely Black Cube, to investigate so-called accusers and journalists. Evidently, this was not, unfortunately, just a Weinstein rogue behavior. It is rather something that is becoming a strategy in international arbitration, as we can see from the examples that I'll give in a while. And what exactly are private intelligence agencies? So these are firms that have been founded by former operatives from intelligence agencies from the government. Black Cube, for example, has been founded in 2010 by former Mossad agents. Then you have Hacklet in the UK, which was founded by former MI6 agents. You have Kroll, which was not founded by a CIA operative, but staffs many CIA and FBI former operatives. So you have this burgeoning field of private intelligence that they describe as corporate intelligence, and their detractors describe as corporate espionage. Obviously, the scope of activities of these firms is not always illegal or unethical. You know, you can do investigations through research on public records, web scraping in the public domain, interviews that are consensual. You certainly have expertise also held by these private intelligence agencies that venture beyond the realm of legality because they do know how to do covert GPS tracking, device hacking, wiretapping. So they are spies in the end. But I do not want to focus so much on the legality of these actions because these, let's say, are the easy kind of cases. I wish to focus on the gray zone of their actions, which is, I'm calling the covert operations. Because these covert operations, they rely on the premise that lying is not illegal, deceiving in itself is not illegal, manipulating is not necessarily illegal. And these covert operations, they may target a range of actors in an arbitral proceeding. They may target the counterparty, the witnesses of the case, the counsel, and even the arbitrators. So perhaps now I'm being too abstract. I wish to go even more in a concrete situation to understand exactly how this may come into play in arbitration. And I wish to illustrate this with 3 examples. First one happened in Canada against a former judge and arbitrator. This former judge, when he was on the bench, he decided a very rumorous case against a financial firm in Canada. Then he retired. The case got to the appeal stage. The firm hired a private intelligence agency to obtain compromising information or information proving that this judge was biased. So the private intelligence agency lured the judge into meetings that were recorded without his knowledge, trying to obtain anti-Semitic remarks because the controlling shareholder of the company that hired the intelligence agency was actually Jewish. The judge and arbitrator did not fall for the trap, but the whole story became a big scandal in Canada because, you know, you have now an adjudicator being lured into this meeting to obtain, compromising information. And here, I think the interest of this situation is that you can imagine in the future conflict checks and challenge of arbitrators observing more and more of this type of evidence. Arbitrators being targeted in these operations to, meetings where they're actually meeting people using false identities under false pretenses just to obtain compromising information on potential biases. Second example happened here in New York in enforcement proceedings between 2 Brazilian companies that were in an arbitration in Brazil. Obviously, the winner wanted to enforce the award here. It hired a private intelligence agency to find assets from its counterparty. In the end, the private intelligence agency did uncover a very complex mechanism of asset evasion. But what is interesting in this case is that the investigation relied a lot on the interviews conducted with the CEO of a Paraguayan bank that used to be to act on behalf of the counterparty. And although the file does not show any proof of illegality, I wonder what would happen if we realized that the interviews were conducted consensually, but through manipulation or some sort of psychological leveraging. What would be the attitude that the tribunal would have to take in this situation? And final example is taking place in an ongoing case at ICSID. It's on the public record, Alicia Grace and others against Mexico. You have, again, a private intelligence agency being hired to obtain compromising information from officials, Pemex officials. They've been lured into meetings under false pretenses being recorded and so on, just like the previous case I described. But, and they did obtain supposedly evidence on corruption practice, which is to be decided by the tribunal still. But what I want to highlight here is that on the file of this case, we also find information that the private intelligence agency has contracted with the party that hired it a success fee of 3% of any amounts recovered in the case. So what is the relevance of this success fee in investigations conducted, especially using those methods that are very questionable? I will now just sketch some thoughts on the limits to the use of this evidence, more or less based on what Clara just said. And here I want to highlight two elements, equal treatment and the interest of a good administration of justice. Because I think equal treatment, especially in investment arbitration, provides a very good way of dealing with these practices. We know that there are few arbitral tribunals that have already ruled that the states cannot use its security services, intelligence operatives to harass and harness evidence against the investor, misuse its services. So evidently, I believe equal treatment, notion of equality, would just imply that the prohibition runs both ways. If the state cannot conduct covered operations against the investor, why would the host state or the investor be able to conduct these covered operations against the host state? It's just unclear. And we find, even in Methanex, a very old case, a reference to this idea that the prohibition runs both ways. The problem is that this notion of equal treatment is less useful, I would say, in terms of commercial arbitration, because in theory, both parties could hire private investigators to build their case. And in the context of commercial arbitration, I think the problem really is a systemic one, because if we allow this behavior to take place, it will become naturalized, and the more parties use, the more they feel compelled to use to build their case. And then instead of promoting a good administration of justice built on notions of fairness, loyalty, and efficiency, we're actually promoting, I would say, disloyal behavior. We're going to be promoting deceptive and manipulative operations against numerous parties to the proceedings, but also we run the risk of fostering violations to the rights of third parties, because not only the people directly involved in the case are targeted by these covered operations, also other people are involved. And in addition to that, this very unorthodox method of gathering of evidence promotes longer and more onerous instructions, because evidently the counterparty will challenge the evidence produced in such a way. So we will have to engage in a very lengthy and controversial discussion about this. So my concluding remarks, to stay on time, is that arbitrators, they have the duty to promote equal treatment and also a good administration of justice, and they have to sanction unloyal, unfair, and inefficient behavior, which I think is the case of these covered operations conducted by private intelligence agencies. Thank you very much.
My turn? Thank you. First, my thanks to the organizers. This is really, it's an honor to be here, and it's been an honor to read the papers, the drafts that I received from the two presenters this morning. They're both very thoughtful and and are dealing with very provocative, current and important issues. And so my critique is, I think, going to be more in the way of raising questions, which I hope will engage some discussion. So I have to tell you, in reading the papers and hearing the proposals made, I come at this from the perspective of a practitioner, meaning counsel, and from the perspective of an arbitrator. But I have to say my reaction was, isn't this a systemic problem? I find it distressing that, that there would be actors in the marketplace who do the kinds of things that we've heard described and do it because they believe there is obviously an economic incentive for them to do it. But more importantly, they only do it because they know it will be purchased and it will be used. And if it appears in the marketplace, the global marketplace, that this kind of conduct that is either outright illegal or that borders on the illegal is acceptable and is desired by one of the parties to a proceeding, then it will be engaged in. And I think the larger issue that these both papers present is, what do we do from a systemic perspective? And it's not a national perspective, it's really a global perspective. And so the first question I asked myself is, what would a national court system do when confronted with the kinds of information that's being procured by covert operatives all over the world? And so what I think about immediately is the fact that every national legal system has some kind of code of evidence. And at least in law schools here in the United States, I see students carrying around a huge book that's called Evidence, and it has rules. And the principle behind those rules are that rules are important to ensure the general reliability of what's presented to the adjudicator, that the sources of that material are identified, and in some ways, most importantly, that when it's presented, it can be confronted. It can be responded to by the other side and evaluated for its probative value. And although we can criticize the different national codes of evidence that exist, and some of them are very, very detailed, and of course, arbitration is very different on the continuum from a national system, those codes serve a purpose, and the ultimate purpose, I think, is to safeguard the integrity of the adjudicative process and to ensure that the parties to the process will have an ability to respond to the accuracy and the value and the truth, ultimately, of what's being presented. And so I think that's what's really always behind the codes, whether one likes them or not. And of course, on the other side of the continuum in international arbitration, we take great pride in the fact that the system has very few positive requirements. There are principles that we must follow, but very few specific, detailed rules when it comes to the quality or the quantity or the sourcing of the evidence that's presented to a tribunal. And so I think the cases that have been discussed this morning are excellent in pointing out how tribunals have addressed these problems. But the question is and there needs to be a framework, and I think the suggestions that have been made are very positive, but what is society at large to do about this? Is it sufficient that this is a tribunal issue, or is it, as I said to begin with, a systemic issue? And the reason I raise the systemic issue concept is, I think if this is engaged in, and if it is an issue for each specific tribunal on an ad hoc basis to resolve, what's the impact on society? Will this kind of conduct be encouraged or discouraged? Will it only be an issue of how much, how likely it is that it will be successful in being able to be used or not? And I think those are important things to think about. The other thing that strikes me is, how does this intersect with the issue of ethical conduct? In international arbitration, we've talked a great deal about what are the obligations of counsel in the course of conducting an international arbitration, knowing that the attorneys, the counsel that appear in proceedings come from different countries, from different legal systems, and that are each governed by different systems of codes of ethics and codes of conduct. Aren't the questions that have been confronted by the tribunals in these cases really in large part questions of ethical behavior? Questions of what is appropriate to be used, what are the guidelines that govern the acquisition of information, what are the duties that each party owes to the other. Now, clearly, tribunals have used the standards of good faith that are obviously either express or implicit in many of the statutes and rules that govern international arbitration. But isn't this an area where the question of the need for ethical standards generally and the need for some guidance on what kind of evidence is to be presented, don't these two things really intersect in connection with these examples, these cases? And isn't this something that on a global level or on a professional level we need to try to address so that it is not a tribunal by tribunal issue, but it is really a practice of international arbitration, globally issue, that gives us some guidance that's useful and that all parties, whether it's in the treaty context or in the commercial context, are bound by. I think that the two papers and the examples and the suggestions that have been made do an excellent job in sort of raising all those questions. But I think the challenge for the profession is how do we address them? And do we address them by providing tribunals with guidance, or do we try to do something that's on a greater scale that's more systematically focused as opposed to tribunally focused? We're interested in your views.
The floor is to the audience.
You should feel free to ask questions, okay? I'm watching, okay?
Yes, please.
Hi, I have a question with regards to what Bruno was mentioning about an arbitral tribunal, establishing that governments could not use intelligence or undercover operations against investors in a couple of cases. How do you deal with other legal frameworks in international law, like, for example, the United Nations Convention Against Transnational Crime, that allow for governments to cooperate by means of judicial cooperation in performing these kinds of undercover operations and intelligence? What I mean is that in international law, intelligence and undercover operations is usually allowed, and within the domestic context also, if investors or private actors have committed or are suspected of having committed crimes, states have the prerogative to investigate them, and that would be legal. So, and my other question would be, what would be the legal framework that allows these private companies to investigate other actors? What would be the legal framework? I believe states, or at least where I come from, which is Colombia, where I come from, states, private companies cannot investigate or do undercover operations against other individuals. That is a prerogative of the state. So I was wondering, how would you deal with that?
Thank you very much for your question. With regards to the first question, I think the tribunals, the decisions that exist on the matter, are not saying that states cannot conduct covert operations or that they cannot prosecute investors. This is not what they're saying, I think. I think they're saying that this should not be used as a strategy to conduct your litigation, right? Which is something different. Obviously, criminal proceedings that may take place against an investor or against anyone. But if you are deploying this with the purpose of gathering evidence that is not damaging or to harass, which, again, it's difficult to prove, it's a very gray zone, it will be object of discussion in proceedings, but the notion itself, the principle should be clear, that this cannot be used as a tactic, a procedural strategy, right? I think this is the idea. And you have, I think, in Libananco against Turkey, there is a discussion on this, because in that case, Turkey conducted illegal, actually, I think, tapping of phones, but the tribunal was saying, well, you should keep criminal proceedings and investment proceedings apart. And let's bear in mind that criminal proceedings, they operate under the premise that the accused is presumed innocent until proven guilty. So obviously, if the investigations are ongoing and you don't have a final decision on the matter, like you cannot just bring this to the tribunal, like, because you have privileged access to that information. I would say that would be my opinion, if you're asking. With regards to the second, so then you also had a question on the United Nations Convention on fighting corruption. Again, I think it's not a question of precluding criminal investigations, which was more or less my answer. And then with regards to the third question, which related to the legal framework for these investigations. And this is actually the very interesting thing, because there are many discussions on this matter. Some people think it is illegal, but the firms themselves, they usually present their actions as, again, as I said, it's not, I can't come to you and say, my name is Jose and my name is Bruno. This is not a crime. And I may lie to you and say, let's have a coffee because I wish to hire you as a lawyer, although I have no intention, and we may potentially have conversations. So the legal framework usually comes into play with regards to one-party consent recordings, and they tend to say that, well, they only do these recordings in jurisdictions where one of the parties consent to the recordings, themselves being one of the parties, to the conversation. So it would not be legal, because then they can record, and everything else was just maybe unethical because they're lying and they're acting under false pretenses, but this is not necessarily illegal, right? So it's not that they are conducting a covert operation, as they're simply being this, perhaps being deceptive, lying, but this is not necessarily a crime, so it's okay. This would be the gray zone that I referred, because it's not very clear if this falls into the prohibitions that exist. Right? Obviously, wiretapping, no, this is illegal. GPS tracking, hacking, illegal. As I said, these cases are the easy ones, I would say. The question of, is lying and manipulating illegal? Depends, right? Because blackmailing is, maybe fraud, something like this, but something more mild would not. So we are operating in the gray zone. Evidently, there is a question of regulation that will have to come into discussion in a few years. I think in the UK there is a report in Parliament from 2012 on private investigators that relates to this problem, actually the rise of private intelligence agencies. But you don't have any specific, to my knowledge, regulation dealing with this field that is emerging.
Thank you, very interesting. I was wondering what's your opinion on the potential risk of unconscious reliance of the arbitrators on the evidence once they've seen it, right? Because you can have all these debates back and forth between the parties as to whether it has to be admitted, but once they've seen it, I mean, there's at least a risk that each of them is going to consider it, and probably they're going to deliberate about it as well. So what's your opinion on that?
Sure. I think that's a very good question, and I think this goes down to psychology more than having a legal framework to deal with it. So I think obviously once a piece of evidence, even if it hasn't really been introduced, if there's a description of the information that you can find in a certain document or video or some recordings of any sort, obviously I think it's very hard for, I mean, I've never been an arbitrator, but I imagine that it's really hard for an arbitrator to then pretend you haven't seen it. But then I think there's the other question of, even though you've seen the information contained therein, there should be a stand or a decision that you take with regards to this document, and because then the duty of the arbitrator still remains to render an award that's enforceable and that can be used and to sort of avoid any further conflict or issue that can arise. So there still needs to be a decision taken and a framework to apply, but I think this is an excellent question, which I don't have the answer to. I think psychologically, it's very hard to pretend you haven't seen something you've seen. So maybe Benno has further views on this, but.
This is a serious problem for sure. And in the area of attorney-client privilege, and we may hear about that later this morning, one of the solutions that tribunals sometimes employ is to have what we would call either a special arbitrator or a master appointed for the sole purpose of reviewing the materials that are alleged to be privileged and therefore not admissible, so that the tribunal that's going to have to resolve the case is not exposed to them and does not make a decision, does not have to see them in order to have a decision made. That's one practical way to deal with it. If it turns out that the systemic problem of seeing these kinds of issues coming up more and more frequently arises, then maybe there needs to be a provision put in procedural orders generally that requires counsel to identify early on in a proceeding types of purported evidence that will be presented to the tribunal in the course of the case, so that the tribunal has some expectation that it may need to set up a special process for dealing with the admissibility of that evidence. Because sometimes this only arises once the party attaches the evidence to their papers. And it's in the pleadings, it's in the record, and then an application is made by the counterparty basically to have it excluded. And then members of the tribunal may already have reviewed it. And in order to prevent that from happening, it may be that giving notice becomes an easy procedural requirement if you can anticipate that this may come up.
I would like to come back to the topic of the legal framework to assess the problem of admissibility in general, because you mentioned general principles. Benno has talked about the local codes and the detailed regulation in local codes. But I wonder if it is really possible and can say desirable to have a kind of international standard adopted by some private or some institution. Do you think it's feasible, Clara? Do you think it's a...
I think so. I think, as I was mentioning in the introduction, there's different roads that you can take when you're faced with that issue, and one of them could be to refer to the Lakes Arbitrary, which then doesn't require a general framework. But I think having seen a few of these cases, none of the arbitral decisions that I've seen and that I think we're seeing today are really dealing with this issue of how do we tackle illegally obtained evidence or unlawfully obtained or through other questionable means. And none of these really have this clear path to follow. And I think it's missing. And I think having a framework that across jurisdictions we can refer to is something that would be very important in providing efficiency and predictability. And I also think on a more general level, and what you were talking about, Benno, and commenting our papers in a systemic level, it would ensure that we don't have the field of arbitration sort of excluding itself from the other, from the rest of the world in dealing with issues that arise related to technologies, for example. If I mentioned a few cases that have more clear questions, for example, the Methanex case in which the party clearly went into the other party's trash. So that's a question that we can really take and tackle in itself. But then you have all of these questions that may arise in terms of how do you deal with evidence that was obtained on WikiLeaks or the Kazakh Leaks websites that has initially been hacked, but then provided on a third-party website that hasn't really been involved in the proceedings, or that doesn't have anything to gain or lose from its outcome. And then I think you have a different issue, and there's nothing today that really allows tribunals to have clear guidance. And I think these general principles and this general framework would allow them to ensure that we take a decision that is in line with whatever is going on in the world and with the...
Who should elaborate that according to you?
That's a good question. Because, yeah, that's a good question.
Because if we think, for example, UNCITRAL, and looking at the recent works of UNCITRAL, and in particular the ongoing discussion, I'm not sure that is the most appropriate. It is the most legitimate, and every state is represented, or at least potentially represented. And also different stakeholders are represented there as observers. But I don't know, maybe it is doable mostly by institutions like IBA, or I don't know, or arbitration institutions trying to collaborate in that. For example, when you apply ICC, when you are under the aegis of ICC, you apply our rules on admissibility, for example. I don't know. And so the parties are already committed to that because they have selected ICC rules.
Yeah,
Just
no,
to
absolutely. I think that's a very good point and definitely something to further explore. But
Can I just perhaps just say one thing about this? The question of the forum, I agree, it's a very problematic one. But I also don't think we need to just say, well, this global regulation has to be done here or there to the exclusion of the other ones. If we have different institutions dealing with the matter, I think it's already a very good thing. The conversation has to be started, and if we have different codes of ethics, let's say, in different institutions, it's not a problem because over time we've seen this in many circumstances. Gradually they will converge, I imagine, because we see a lot of convergence even between procedural rules, institutions, the expedite arbitration, they are all marching to the same direction. So the question is, starting the process, perhaps at the IBA, UNCITRAL, it doesn't matter, I think. Obviously, IBA would be a good forum, UNCITRAL would be a good forum, but the conversation has to be started. Institutions should also start undertaking this discussion on the code of ethics, code of conduct, not just to arbitrators, but to everyone involved. Because some things, I believe, have to be ruled out, even if they're not illegal. Like, we don't want to turn arbitration into this battleground where everything is available, and now we have arbitrators being, spied on and have their phones tapped, and they're being lured into meetings, under false pretenses. So it's not the question of legality, it's also a question of ethics, as been referred to. And this conversation has to start.
Yeah, just to follow on what Bruno said, I think it's important that globally international arbitration is viewed as a credible, principled alternative to the national courts. And so anything that, any cases that suggest things can be done in arbitration that can't be done otherwise is not really good. It doesn't promote the confidence in the system. And so the conversation is very important. How it's dealt, who deals with it is another challenge too. But having this conversation and making clear that this is not, that the system does not accept that kind of behavior sends a very important message and signal, I think.
Do we have time for one last question? Yes, one more. Please.
Great. So good morning. First off, thank you to the panelists, which includes one of my good friends from undergrad, and thank you to the organizers, my former professor, Fernandez Arroyo, my current professor, Ferrari. I'm interested in one of the assertions made by the panel and then followed up on by one of our guests here, and that deals with the value to society of using private detectives in this kind of proceedings. So on this note, and in the context of investment arbitration, I think it's fairly easy to frame the use of private detectives by investors in negative light. It goes something along the lines of the almighty investor versus the weak, vulnerable state, right? Which is generally developing, poor, doesn't have very strong institutions, and they're up against a wealthy international investor with plenty of resources who's attacking their, maybe their their state organs, right, trying to fish out this information. That said, many times these investors have actually been wronged, right? And in fact, here I speak from experience, having been involved in a case where detectives were hired. So we discovered that the state had orchestrated murder plots against the client. We discovered that they had created political campaigns against the client as well, that they had expropriated their business, they'd created phony criminal charges against the client. Now, none of this would have been possible without the use of the private detectives. So then I asked myself whether these agencies or the use of this type of operatives in international investment proceedings add value to society. And I think the answer in this case is definitely yes. So we need to perhaps have a more moderate approach and not fall victim to the traditional, I'd say, argumentation that it's the wealthy investor against the poor state. So how do we really fare with rogue actors like this who are not afraid of using illegality to target investors? Should we allow them to do it and not use or not fight fire with fire? Or how do we really approach this question?
Thank you very much for your question, but I think you just built a straw man, because I didn't say that detectives should not be used necessarily. I actually started by saying that many of what they do can be legal and can be ethical. But my focus was rather on a specific type of operations that may be conducted by these emerging private intelligence agencies. And I've never referred to the almighty investor against the weak states. What we see in the case law is actually like the prohibition against the use of security services and intelligence agencies being developed against the state. That is, the state should not use security services. The state should not promote undercover operations against an investor. Obviously, targeted killings, obviously, all what you described is not being condoned by any investment tribunal or a commercial, I suppose. So, yes, detectives can and may be useful. They can add social value. But what are the boundaries for their behavior? And even other detective agencies, if you start reading the debates on within the investigators community themselves, it's very controversial, the tactics that are being used by some of these agencies, right? And what I'm actually trying to raise here is, are we to accept the fire-by-fire attitude? Let's say a state, because we're talking about investment, but this is not exclusive to investment. We may have commercial disputes, as I just referred, where both parties are actually targeting everyone. Tapping phones, hacking devices. Imagine you are indirectly related to this dispute because somehow you had dealings with the company, and now you're being investigated by this former Mossad agent, and you have people inside of your house and kind of like intimidating you. My question is, are we to accept anything goes in the logic of anything goes to win the case in arbitral proceedings, whether investment or commercial? My feeling is no. This is not, again, to say that let's ban detectives, let's ban investigators. No, obviously they can act. But like everyone else in any sort of dealings, they have to act under an ethical framework, not just a legal one, as I said. Because we should not just stop at the legality threshold. Legality is a very important threshold, but there are things that are not necessarily illegal that should not be done because they break boundaries that, from my perspective, are not appropriate for the purposes of arbitration. Arbitration is not here to aggravate disputes. It's rather implemented to promote an adequate, efficient, courteous, maybe I'm being idealistic, but courteous method of dispute settlement. But we are seeing more and more arbitration become this battleground where people are just trying to kill each other. Is this the purpose of the proceedings? I'm not sure. So this would be my answer.
Thank you very much. And I think this has to conclude our talk. I thank our speakers and wonderful critique of this presentation.
So thank you very much. As you've seen, we have a 10-minute break. Then we'll deal with completely different issues, meaning issues of law applicable. We'll resume at 10:15.
Good morning. I think we can begin, right, Franco? Thank you. I'm delighted to be here with you together with my esteemed colleagues on this panel to discuss the very narrow topic of open questions in international arbitration. I'm especially delighted to be here in this beautiful room, in this wonderful academic institution on the occasion of a symposium organized with my beloved alma mater, Sciences Po, and with that, thank you to Diego and Franco for inviting us and having us. And before we begin with the fascinating presentations, I'll spice it up a bit with respect to my former moderator and start by briefly introducing my esteemed colleagues. First, we have Paula Patarroyo, who is a legal officer at the United Nations, a Colombian national. She pursued her legal education in Colombia at Universidad de La Sabana and received an LLM from NYU. She clerked at the Constitutional Court in Colombia, was a legal officer at the Colombian Ministry of Foreign Affairs, and worked with several international arbitration law firms in New York and Colombia before joining the UN. Jonathan Schaffer Goddard, please correct me if that pronunciation is wrong, is an associate at Hallwell, Schuster & Goldberg in New York City, where he practices in international litigation and arbitration. Jonathan holds a bachelor's degree from the University of Oxford and a legal degree from Oxford Brookes Law School. He also pursued his LLM at NYU. Everything stays within the institution. Prior to joining his current firm in New York City, he practiced as a barrister in London, where he remains a member. And last but certainly not least, Brian King, who hardly needs this non-exhaustive and very humble introduction. Brian counts nearly 30 years of experience practicing as an international arbitration lawyer in both commercial and investment disputes. Until December 2018, Brian was a senior partner in the arbitration group at Freshfields Brookhouse Deringer, based here in New York, and he now practices as an independent arbitrator. He's, as most of you know, acted as counsel in more than 100 cases, including 2 of the largest investment cases to date. Brian holds a BA from Princeton and a JD from NYU, and after graduating, he clerked for federal judges in New York and DC, and also practiced in a Dutch firm before joining the Amsterdam office of Freshfields. Now, while there are many open questions in international arbitration, we have chosen 2 of them today to discuss with you. Both of these questions can be qualified as open, not only because they are so-called hot topics in international arbitration where a settled or a uniform approach is non-existent, but also because there are questions that are, these are questions that are open and may somehow remain open in the process of the arbitration until the issues actually arise, which can make it very difficult for parties and the tribunal to determine the adequate approach at the beginning of the process. I doubt our presenters will close the questions, and with the help of Brian might even open them more. But first, we'll hear from Jonathan on the topic of the law applicable to privilege in international arbitration, which, as many of you know, presents a question, an open question, if I may, of conflict of laws, both because of the lack of certainty regarding the adequate conflict of law approach, and because it remains a relatively underdeveloped topic. The issue of privilege in international arbitration proceedings is normally dealt with on a case-by-case basis by tribunals when the dispute about an assertion of privilege arises in the arbitration. Then Paula will present on the topic of which regime for the adoption of interim measures by the arbitrators, which deals with an important tool to ensure the effectiveness of a decision on the merits of a dispute that is normally used by a tribunal at a time when the outcome of the dispute is still uncertain. And now the outcome of the arbitration or the dispute is not the only thing that is uncertain, given that there's no single applicable law to interim measures, as we'll hear from Paola. A friendly debate, I hope, will then follow, led by Brian. And I believe we'll have time for questions from the audience as well. So please make sure to note them down as you become inspired so that we're not deprived of your curiosity or thought-provoking comments. No pressure. Without any further delay, I yield the floor to Jonathan.
Thank you very much for that very kind introduction, and thank you as well to the organisers of today's conference. It's a real privilege and an absolute pleasure to be here. As has been said, I'm going to be talking about the question of the law applicable to privilege in international arbitration, and I think it's best to start by setting out the way in which that question might arise during proceedings, because I think that could help us ground the discussion in the sort of situation where it occurs and where the need for a solution arises. So the problem tends to emerge as follows. During the course of an international arbitration, a dispute occurs as to whether or not party A is entitled to assert privilege in a document or a communication. Under the law of the domicile of party A, there's one legal test for whether or not that document or communication is privileged. Under the law of the domicile of party B, there's another rule. The law of the arbitral seat provides a different rule. The substantive law of the contract may provide a further rule. The law of the jurisdiction where the party's legal advisers are admitted may provide a further rule. And the law of the jurisdiction, or indeed jurisdictions, where the document came into existence or where the communication occurred, may provide other rules. Now, under some of these rules, the document or communication will be privileged, and under some of them it won't be. And it may often be a very, very important matter whether or not it is privileged. And that is especially so in relation to the two sorts of privilege that I'm going to focus on, which are the sort of legal professional privilege and without prejudice privilege. Side note, we can talk about other privileges, clergy penitent privilege, psychologist patient privilege, but I'm going to leave those to one side as they tend not to be quite so relevant in the context of international arbitration. More's a pity. But the determination of privilege is going to be of quite some importance to the parties. If this document which one party thought was privileged is not privileged, they may well find themselves at a substantive disadvantage to where they thought they were in the proceedings, and vice versa. And it is therefore, I think, a matter of some regret that this question tends to arise ad hoc in the moment. And that's not just least because that may not be the best way to resolve the question, but also because it makes settlement discussions more difficult, both in terms of the question of whether or not they will remain privileged, but also when you're weighing up your odds, you may want to know whether or not you're going to have to turn over all this information or not, and how that might affect your case or the credibility of certain witnesses. But also because, and I think this is the important starting point, privilege is, in my submission, a substantial and weighty right. And it's a right that pre-exists the arbitral proceedings. And that's where I want to begin teasing my way towards what I'm going to try and do, which is give a definitive answer to this question. So it is a substantial and weighty right. It's a right that arises at the time the communication occurs, when I pick up the phone to my lawyer and ask for advice, when I pick up the phone to the other side and begin settlement discussions, when I write a without prejudice letter. The right arises then. That may well predate the signing of the contract. It may well predate the commencement of the arbitration. It may well predate the selection of the seat for the arbitration. But these rights are rights which the parties bring to the arbitration. And so when we're determining what the scope of that right is, and as the earlier question, what law gives the rule to determine the scope of that right, we are dealing with, in my submission, very important rights, and that's why it's particularly important, I think, to get this right, and why, in my submission, when you look at the approaches taken in general, it's quite unsatisfactory. So I want to look at the sort of conflict of law rules that are applied. We have all these different potential national laws that would give you a rule to apply to determine privilege, but what are the conflict of law rules that are applied? And here it might be worth just looking at what national courts do and how that then translates across to arbitration. So starting in the United States, federal courts tend to apply, well, we can look in two ways in the US, both interstate and internationally. So starting interstate, federal courts apply the conflict of law rules of the state where they sit, as all the LLMs here hopefully know by now. And they apply that to determine the law applicable to privilege, which leads to application of the first restatement in some cases, the application of the second restatement in some cases, the application of governmental interest analysis in other cases, and a contact grouping test in other cases. And these four methods all give very different ways of determining the applicable law. The first restatement was silent on privilege, and the general rule assumed is that it's the law of the forum. So wherever you happen to be hearing that, whatever state the court is sitting in, that is the state whose law governs privilege, regardless of where the communication happened. So if you've ended up being sued in Minnesota, for example, Minnesota privilege law may, if Minnesota applies the first restatement, and I can't remember off my head if it does or not, Minnesota privilege law will determine the privilege applicable to your communications in California with your California attorney. Potentially a surprising result. The second restatement is a two-pronged test that basically everyone agrees is rubbish, he says firmly, but it genuinely is quite a bad test. It's very pro-admission. Evidence that's not privileged under local law of the state, which has the most significant relationship, will be admitted, even though it will be privileged under the local law of the forum. And evidence that's privileged under the local law of the state, which has the most significant relationship that's not privileged in the forum, will also be admitted. Governmental interest analysis, contact grouping, I think the less said about those, the better. But when you look at approaches taken in the literature, you'll find academics who suggest applying Loeffler's choice of law approach to determining this, and various other rules. In the international context in the United States, you have the touch-base test for privileges. This is the Gucci and Guess case in the Southern District and Second Circuit. And that is a more nuanced test. The court in Gucci Guess emphasized that the touch-base analysis is not necessarily focused on whether particular documents are located or where they are where the situation of the person when communicating is, but rather whether there's a more than incidental connection with the United States. And there the focus was on whether it's advice in relation to US proceedings or on US law, in which case it's going to be dealt with under US privilege rules, and if it's foreign proceedings or foreign law, under the relevant foreign law. The UK has its own approach in, I think, quite typical English fashion. The English courts say it's our privilege rules that matter. Doesn't matter what the privilege rules were elsewhere. The leading case there is the RBS rights litigation. I think that rule, for reasons that I'll come on to, is wrong, and that case was wrongly decided. But English law treats the question as simply a forum law question. So, briefly, I want to set out what I think the correct answer is here in the context of international arbitration. And to do that, I want to first ask, what ought the rule to be like? In my submission, the rule ought to be predictable in its application. It ought to protect the justified expectations and reliance of the parties. As you started off with, this is a right you bring to the arbitration, your privilege, and it should be protected. And it ought to be easy to apply. And the reason for that is that the rule may only be applied to dozens, hundreds, maybe even thousands of different documents and communications. And you can find exciting multi-district litigation in the United States on a cross-state basis, where literally thousands of documents have had privilege determinations following this conflict of laws analysis. So in my submission, the rule needs to have those three virtues. It needs to be predictable, it needs to protect the justified expectations and reliance of the parties, and it needs to be easy to apply. That, in my submission, rules out what is often the common default answer, which is that the law of the seat should apply. I do not think that is right. The reason for that is, firstly, the law of the seat does not necessarily respect the legitimate expectations of the parties. If you have entered into communications with your California attorney on the risks that arise under a particular clause in the contract, and you wish to have that, and you consider that advice privileged when you enter in, when you receive it, prior perhaps to signing the contract, only to discover that the Singapore seat with Singapore privilege rules will not treat that as privileged, you'll be rather surprised. You'll probably be quite upset. Your legitimate expectations and the reliance you've placed on the privilege that governs that relationship with your attorney have been, I think, violated in some way. Secondly, when courts apply the law of the seat in litigation settings, it's often related to the public interest factors that are special to courts. It is this jurisdiction which is determining this dispute. These are matters for this jurisdiction's courts to determine. Those public interest factors have much less weight in the context, I think, of an arbitral seat. And then finally, there is in my submission a better option. I want to sketch out that better option now in my remaining sort of 45 seconds or so. And that is, in my submission, the appropriate rule is that the law of the attorney who gives the advice is the law which should govern. So if you are a New York attorney, it is New York privilege rules that should govern advice, work product, that sort of litigation privilege. If you're a Colombian attorney, Colombian privilege rules. German, German, English, English, etc. That is a territorial solution. It is necessarily tied to the place that the attorney is. That is admitted. And that has many virtues in my submission. Firstly, it's predictable. You can tell very easily what privilege rules will apply. Secondly, it respects the justified expectations of the parties. A party consulting a California attorney will expect California privilege rules to apply. They will not expect Colombian privilege rules to apply. So there's no going behind or undercutting the expectations of the parties. It's also easy to apply. Where are they admitted? It is as straightforward as that. I will say one final thing, which may be a point for discussion. Many arbitral tribunals faced with this do something a bit funny in my submission. What they do is they say, well, there could be this privilege rule, there could be this privilege rule, there could be this privilege rule. Rather than determine which one, we will apply the most protective one. Because that way no one can complain. And this is born out of a desire to treat the parties equally. And I can see the sense in that. But in my submission, that's not the appropriate thing to do, because treating parties equally does not mean necessarily treating them identically. There is very little reason, in my submission, to grant a wider privilege to someone who had no expectation of that wider privilege, did not communicate on the basis of that wider privilege, simply because the counterparty has a wider privilege. So long as each party's legitimate expectations are respected, they are treated equally. There is no need to treat them identically. And that avoids the difficulty of privilege becoming a crowding out mechanism where it is overly exclusionary. And I think that cough means I've definitely overrun. I'm going to end there. Thank you for listening, and I look forward to this cross-examination that's to follow.
Paola?
Thank you, Sylvia. Thank you very much to Professors Ferrari and Fernandez Arroyo for this very kind invitation. I would start perhaps with the regular UN disclaimer that this is in my personal capacity, as I'm sure it's the case for all of the panelists and colleagues taking part. It's great to have a setting, to have this type of, I would say, academic, but very practical discussions on various issues. I think that my task in relation to the analysis of the law applicable to interim measures is one to try to seek some clarity of what these open questions are and what type of categories, in my opinion, of questions we are dealing with that take us or that require a law applicable analysis. So I have proposed and will identify three boxes, drawers, categories of questions that we may face or that may need a law applicable analysis when we're talking about interim measures. As Sylvia mentioned, at the time that the measures are requested, the future of the arbitration is uncertain, but we're trying, of course, to seek a way to safeguard the proceeding or to protect certain either substantive or procedural rights, including the integrity of the arbitration. We have then three phases or categories of questions. First, what I would call the existential question, which is, can arbitrators grant interim measures? Who may request them? Against whom? Which type of measures? How long can this take? These rules, I think, are basically what set out or delimit where we're playing, and that's the playing field that the parties and the arbitrators will be in throughout the consideration of this request. And we may look, of course, at the source, which is the consent of the parties, where the power of arbitrators come in order to determine what the scope of that power is. So we would often have to look at first the arbitration agreement, which would often be silent on specific aspects of interim measures. We may have exceptional circumstances or exceptional provisions, perhaps, in the context of recent investment protection treaties where there are certain measures that are off limits for arbitrators, measures suspending the application of regulations that are challenged by the investors, or certain measures like the attachment of assets that it's off limits for arbitrators as well. Then we seek to a second layer to analyze these existential questions, which is the arbitration rules, part of that consent of the parties. And many of these questions could be answered from that perspective. So the rules of arbitration might often provide some guidance on against whom they have to be requested by the parties. There have to, even sometimes they list types of measures that could be granted by the arbitrators, and they perhaps include, in certain cases, and more frequently in recent modifications to rules, a timeline for the arbitrators to decide such questions. We may have, however, a need to consider additional types of rules. So, of course, the loss of the seat, there is an importance to take a look at what the powers of arbitrators seated in that jurisdiction may be, and that could be specifically relevant in certain jurisdictions where perhaps arbitrators may have no power to grant interim measures, such as China or Thailand, or jurisdictions where there is a different approach or a different regulation for domestic or international arbitration, and there may need to have a specific legal authorization for arbitrators to do that. Professor Ferrari might correct me, but I believe that's the case in Italy, that there is a different perspective of what arbitrators can do on what or how enforceable a measure from, or an interim measures order could be if it's an arbitration seated elsewhere, but that has effect in the Italian jurisdiction. And then we have a particular analysis that I would suggest that has to do more with the parties or the lawyers advising and representing a client in that request, which is looking or trying to anticipate a question that I would address later, which is the potential enforcement. There's a need for the parties to consider, or for that counsel advising that party requesting the interim measures, to consider where is this measure likely to be enforced in case that it's not voluntarily complied with. Is this a measure that could be potentially enforced in that specific jurisdiction? It's a type of due diligence exercise that the lawyers can do, and it may not be evident for the arbitrators to figure out or to just imagine where this measure could be eventually sought or brought to domestic courts. We then get to a second phase or a second chapter of categories of questions, which is the factual questions. When and how can arbitrators grant or deny interim measures? And I guess that's the point that it's more evident when we think about interim measures. Which are the criteria that need to be met in order for the interim measures to be granted? And then we have, again, that question of, well, should arbitrators look at what domestic judges do, what if the law of the seat is silent about the type of measures that could be or the type of criteria that should be followed? And then is there any way in which arbitrators perhaps would rather look at what other arbitrators do, even if the combination of applicable laws from that first analysis is different, even if the other arbitrations were seated in a different jurisdiction or applying a different substantive law or under a different rules of arbitration rules from a particular center. So part of this question, I think, in some form of revelation came up through this research on an article from 1986 by David Caron, analyzing that there was no guidance into how arbitrators could grant interim measures, and going a bit through the theory and practice of interim measures from the Iran U.S. Claims Tribunal. And he rightfully pointed out and questioned how criteria could evolve in a uniform way in the absence of clear rules and without, just completely uniform approaches and interpretations. And I think that even if we have more content or more efforts for the setting of international standards, we still navigate through a false uniformity on the criteria. So often the criteria may be similar from either those combinations of the law of the seat, the law of the, or what specifically the arbitration rules may suggest. Even in domestic jurisdictions, we have common concepts across even legal traditions, etc., but that doesn't necessarily mean that they have the same content or that they are applied or interpreted in the same manner. So what certain more quantitative studies have thrown out, which is basically studies on what arbitrators do when analyzing interim measures, is, well, it tends to be the case that arbitrators would look at other decisions and then even look at what the model, UNCITRAL model law suggests, even if they're seated in a jurisdiction that does not follow the specific provisions of Article 17 of the UNCITRAL model law. So generally, there's 5 criteria that I guess most of us are familiar with, of a prima facie jurisdiction, a prima facie possibility of succeeding on the claims, and then, of course, urgency, necessity, and proportionality, which would also have, I would say, an elastic interpretation based on the type of measure that it's being requested. Of course, it's different when we're talking about an anti-suit injunction, that when we're talking about a security for cost measures, or when we're talking about preservation of evidence, or even just suspending or informing the tribunal of another parallel proceeding that is taking place. So this particular phase, or this factual question of when the arbitrator can grant those measures, is really answered from that more transnational and arbitration-based and practice-based approach, I would say. And then when we get back to that, how that measure is to be granted, we probably would go back to looking at what the arbitration rules may say. Basically, what's the packaging that such particular order or interim measures may go out into. So is it an order? Is it a partial award? How can we make that enforceable? And then that links it also to the following point, which is that third, or I would call it the apocalyptic question of, we have those interim measures, there's an order, there's an award. However, even when most of them could be voluntarily complied, well, sometimes they're not. And then the question is, what now? What can we do? And then there's 2 possible approaches. One question, or one possibility that may seem perhaps more obvious from the law applicable perspective, which is, well, of course, you're in the hands of that specific jurisdiction where you're trying to enforce. And if you followed a good mechanism or a good process in the first stage, when you were thinking of which measures you were going to request, you probably had anticipated where that jurisdiction or what the rules of that jurisdiction are. But it may be also the case, and I think it's worth exploring, what are the mechanisms or the alternatives that the possible law applicable could give to arbitrators to drive or to draw some consequences, perhaps, from non-compliance with interim measures. So it would be, and I think it's probably where there could be more interesting developments in the future, based on basically looking at the law of the seat and at the rules of arbitration, looking at other consequences, such as, for example, adverse inferences that may be limited perhaps to certain types of interim measures, so measures for preserving or giving the tribunal certain evidence. That's allowed, for example, under the English Arbitration Act. Another possibility is for the tribunal to order the payment of a penalty for the delay in non-compliance, which is also a very limited possibility to certain jurisdictions, such as France or the Netherlands. Another possibility is perhaps the suspension or the termination of the proceeding in case that there is no security for cost provided if they were ordered. It's something that has been incorporated in the 2022 amendments to the ICSID rules. And then we have, of course, the damages possibility of, well, if there is injury to those substantive or procedural rights and may give rise to a separate claim, or if they give rise to a consideration of the tribunal in the context of the allocation of costs for the purpose of the, once the award is going to be rendered. So it's truly, and I would say, of course, it's impossible to have a one-size-fits-all in the sense that we have a combination of multiple factors, but that also it would be very fact-specific in the context of what really the right is to be, or what the right is to be protected through the interim measures, and what specifically those measures can do and what is within the scope of the power of the arbitrators. I will leave it there and probably would continue over Brian's questions. Thank you.
Ready for the cross-examination, Brian?
Sure, absolutely. Always ready for the cross-examination, but it won't be that. First of all, the papers are great. First, thanks to the organizers for having me here. Real pleasure. It was a privilege and a pleasure to read the papers. They're both great, well-researched, well-written. And so what I thought I would do with this, and I would ask Sylvia, let's give it 10 minutes, and please raise your hand when it's 10 minutes so we have some time for the audience. What I thought I would do is just ask you each a couple of questions to try to tease out some of the issues that you've raised in these very good papers. So maybe I'll just switch off, but Jonathan, I'll start with you. So I think a central tenet of your paper, and you mentioned it again today, is the assertion that the legal professional privilege and the settlement privilege are what you call well-established substantive rights. So two questions I would ask you to address. First, where do those rights come from? And secondly, at page 6, you refer instead, and you did today, to legitimate expectations of the parties. Are these rights you posit any different than that? And you have 2 minutes.
So the question of where these rights come from, the rights come from national law, the national law of the jurisdiction that you're dealing with.
Well, which jurisdiction is that? Because you told us there's 6 of them.
Again, in my submission, the correct answer there is the national law of the jurisdiction where the relevant attorney is barred. You can look a slightly different approach, perhaps, when it comes to without prejudice settlement privilege, where it's inter-party communication without the benefit of lawyers. But that is where the rule comes from. And I think when you step back from the sort of quick answer there, you can see why we have these rights and why why states and national courts recognize these rights. The settlement privilege right exists for the obvious reason that disputes between parties are best resolved between the parties without recourse to expensive litigation or arbitration. And settlement privilege exists to protect good faith efforts of parties to settle their disputes. There is a clear public policy rationale there. In respect of attorney-client privilege, that is perhaps even more basic, that you are entitled to confidentiality in your communications with your legal advisors. Now, what you'll find is that all the different national laws will frame this in slightly different ways, cast it wider or more narrowly, interpret waiver of it in different ways, deal with exceptions to it in different ways. For example, the rules on the threats exception to without prejudice privilege is different in New Zealand from England, in case anyone was interested in that fact. But that's the sort of the public policy that sits behind it, and you can find, I think, decisions from the European Court of Human Rights which talk about at least the attorney-client privilege as being sort of almost as close to a fundamental right because of its necessity for parties to be able to assert those rights in litigation. And as for legitimate expectations of the parties, I don't think that's anything further than what I've just described. The legitimate expectations come from the fact that when I consult my New York attorney or consult an English barrister, I'm expecting that to be confidential, and if pressed, the proper answer is, well, I'm expecting it to be within the scope of the jurisdiction in which they're barred. So if I the barrister, am advising someone, I think it's right that I can tell them, I can cut, this is going to be privileged, this is not going to be privileged, this is how the privilege works, and they can then rely on that in what they tell me, what they don't tell me, what we discuss, and what advice they ask me to give.
Okay, thank you. Paula, let me move to you. So you talked about security for costs, which is a topic I love because I did the RSM case. And in the paper, you talk about the Herzig against Turkmenistan case, where, as you describe, the tribunal majority ordered security for costs, and then when the claimant said, I can't do it, right, I can't get the money to post the bond, then a majority on both sides reversed themselves and said, okay, you don't have to post it. And I wanted to ask you whether you think that is in fact the right balance. This is really a remedies question. Or should they just have dismissed the claim at that point because there'd been a violation of the order? What does it need to be effective for security for costs?
Thanks, Brian. I was quite struck when I read that case, and in the sense that part of the considerations of the tribunal there had to do in that analysis of the proportionality element, or when assessing what the burden for the parties is, if the measures are granted or denied, they looked at that question of like access to justice, or that specific rationale was really what was underlying that specific situation. I think that the tribunal, in a way, went for an approach that was perhaps more human rights based in the context of having the investor, or allowing the investor to continue with the claim. But it also had to do with how the way, and I think it's a balanced approach from the tribunal in the sense that they still had some interaction with the parties to try to assert really what the conduct is. And I think that it was a completely different outcome, or a completely different also context from perhaps what was the evidence available in the RSM case, which is, well, there's a precedent and there is a record of this same investor really looking or chasing claims that are frivolous and that are really just causing more burden for the state, and they're not really likely to succeed. So it really goes to how the tribunal has to look in a, I would say, holistic way to all of the criteria that need to be present for the interim measures to be granted. And I think that in the case of, in the Turkmenistan case, there was also this kind of like tricky question in the beginning, or at least when the measures were going to be granted, because there was third-party funding. And then the question was, well, if this is not covered by the third-party funding agreement, then what's going to happen? Is the claim just going to end because the claimant is not able to post or cover security for costs? And then the tribunal had a more flexible approach, but then tried to also, I think, defer to a good faith approach that perhaps could be harder to prove for the state in that context than in others where there is an existing record. And it's I would say, a more straightforward analysis in that proportionality, or in that balance of the burdens that the parties may hold in relation to that specific context.
Yeah. No, I think that's right. Certainly the conduct there was less egregious than in the RSM case, and that seemed to move them. Okay, Jonathan, let me go back to you. So the next one is, and you talked about this today too, you said in your paper, you say, look, we shouldn't reflexively apply the same privilege rule to both sides. So we shouldn't take the most favored nation approach, the highest level we apply to both. And the question I have is sort of twofold, but you're only going to have a minute, so, which is the ICDR rules and the IBA rules seem to take a different view. And would it not be fair to say that for purposes of enforcement, that it's safer to take the highest rule, because then you can't be said later to a court that you've treated the parties differently?
It's certainly more conservative, and in that sense, I think it's safer. But I don't think that you have treated parties unequally by not treating them identically. And I think there are good reasons to avoid a sort of race to the top with privilege here and being overly exclusionary of evidence. Again, it's hard for me to see how a party which had no expectation of a communication being privileged when they made it, or a document being privileged when they created it, can possibly complain about it being denied privilege. So I think that complaint on enforcement rings very hollow to me.
Okay.
But yes, certainly it's the safer way. But again, if we're trying to get to the best approximation of the truth that we can, the more evidence available for that, the better in general.
Okay. Thank you. And then, Paula, probably my last one to you, looking at the clock. You talked about in your paper, and you talked about again this morning, the factors that tribunals have looked at in deciding whether to enter an interim measures order. And there are basically 5 of them, as you point out: prima facie jurisdiction, prima facie case on the merits, urgency, irreparable harm, proportionality, including a balancing of the interests. And my question to you, and again, sorry, you have 1 minute, is that all not just unnecessarily complex, right? There's no rule that the tribunals have to follow, right? Why not just do a balancing? Why isn't that enough?
I fully agree that the tribunal is just doing a balancing. I think that the existence of this criteria basically just guide or provide content into how that balancing exercise really comes forward. And it can be helpful in the context that sometimes that request may be very clear, or it may be a classic or a more conventional, perhaps, type of measure where you don't need to follow all of those steps. But there may be, or may be the case, for example, in the Turkmenistan case, you had to have a more delicate analysis of the facts in that context. And you may need to take a look at what the criteria are, but especially how the criteria have been interpreted by other tribunals or in other contexts. So I think that it's really a balancing exercise, and that this criteria or this transnational or international standards really provide just guidance when the question or that balancing exercise is not as straightforward. But I think that in general, arbitrators do have a great flexibility, because in the end, the requirements or this criteria of urgency, or it's not very different from what we have also in domestic jurisdictions.
No, that's right.
It's common concepts that we have across different, even legal traditions, etc. Maybe some of the requests or some of the measures are more exotic in one jurisdiction than in the other, but there's really a common understanding, and that's helpful in the sense that there is a base or a possibility to have a somewhat uniform approach.
Okay. Super, thank you. Well, I think I'll stop my inquisition there. Sylvia, let's hear from others.
Any questions? Franco?
Now, as some people in the room know, I like the lex arbitri, meaning the law of the seat, when it makes sense. So, for example, as far as interim measures is concerned, I do believe that the lex arbitri is the one that should deal with the admissibility of arbitrators rendering decisions on interim measures. The admissibility, at least. You are right when you refer to the Italian legal system. The Italian legal system, for example, does not allow arbitrators, at least not until 30th of June, to render decisions on interim measures. This does not mean that they can't do it, but certainly there's no way to enforce them in Italy. Maybe they will be enforceable outside Italy. Why do I say that? Because I agree with the suggestion made by Jonathan. I do not believe that the law of the seat is relevant in respect of the privilege rule. Why? Because of what Jonathan said. Jonathan, in fact, said that this is something that precedes arbitration. Now, I wonder, and he knows it already, whether the solution is really the application of the law of the lawyer. I say that because when reference is made to expectations, I wonder whether the parties really do expect that there is a privilege rule anyway, and whether it is a privilege rule of the attorney. Let me give you the following example. What if, when trying to analyze the worth of your company, you talk to two lawyers. One is a domestic lawyer and on the other hand, a foreign lawyer, and you send an email to both lawyers at the same time. Does it really meet the expectations of the party that there are two different privilege rules that will apply to one and the same communication? So I'm not sure whether that really is what the party has expected. I wonder whether, as a default rule, and this is a question, and I'm sure you have thought about it, Jonathan, I wonder whether, as a default rule, one should not rather apply the law of the party making the declaration itself, because that really is the context within which that party is operating usually out of, irrespective of whether that party somehow knows whether there is a privilege rule at all. But, you know, I think that operating within a certain context is what one, or the rules in that context is what one expects to find applicable. And it would solve the problem I just mentioned, meaning that one and the same communication sent to more than one attorneys located in different countries will be subject to one and the same privilege rule.
So I think I would start with the sense that many parties will not themselves understand the scope of a privilege, whether that's the work product privilege or attorney-client sort of advice privilege or indeed settlement privilege. And it is generally the job of a lawyer advising their client to explain the scope of the privilege that attaches to communications and to advice. And given that the expertise sits with the lawyer, who will be well cognizant of their rules where they are barred, but perhaps not of the rules in Russia or Turkmenistan or China, where their client happens to be, I think actually the more sensible approach to protect, to sort of provide that privilege is to rely on where the lawyer is barred. You do then get the interesting issues where either there are multiple lawyers from multiple jurisdictions giving advice, settlement discussions, receiving or making communications, where there are dual qualified lawyers, as many in this room will be, who could give advice under both what law of country A and law of country B. I think you just need a prudential rule here, something that cuts through it, and the most senior lawyer, or in that case the most protective privilege for that single communication may be the best way of doing it. And I don't think the same objections that you find with most favored nation really arise when dealing with a single communication with multiple lawyers. So whether it's the most protective or least protective, I think that can solve it when you look at a single communication with multiple lawyers. But for the reasons given, I think I prefer the privilege of the jurisdiction where the lawyer is barred over the domicile of the party, wherever that happens to be.
May I, Jonathan? So what about Brian's question in this context, however? So you are a party from country X. If we were to accept that the rule should be that if you are from party X, your privilege rule, meaning that of the party rather than of the lawyer, should apply, wouldn't it also solve the issue mentioned by Brian? Because, I mean, at one point at the post-award stage, when you either try to annul or to withstand recognition and enforcement, opposing party could say, why? The arbitrator did apply your rule, and this is a context within which you are actually operating. And the arbitrator did apply to party Z's documents, party Z's rule. So, and it goes to what you said. Of course, then the arbitrator could also say, and the party resisting enforcement could say, look, identical treatment is not required, but equal treatment. So the arbitrator has indeed applied different laws, but treated them equally because the arbitrator has applied each party's own privilege rule. Wouldn't that also somehow solve the issue, or at least address the question mentioned by Brian?
I think it would. I think that's, you know, I think that it solves it in a similar way to what I suggested. But again, I come back to the problem, which is this: if I, as an English barrister, am advising a Russian client in a international arbitration, or that's not really sort of popular example these days, but you know, if I'm dealing with a Russian client, a Chinese client from Turkmenistan, I, as an English barrister, do not know the privilege rules in Russia or China or Turkmenistan or Colombia or Chile. I can ask a Colombian or Chilean lawyer, but beyond going, you know, unless you're expecting your attorney to go back again and again and again to check the niceties of this exception or that exception to the rules, or the scope of this or the scope of that, or does it extend here or there, you're asking a huge amount there of lawyers who advise parties in these international contexts. And you're going to have to ask that of the lawyers because the parties themselves are unlikely to know. If you apply the law of the jurisdiction where that lawyer is barred, they can be assumed and ought to know or be able to establish for themselves the privilege rules that govern advice in the jurisdiction where they are barred. And that is a much, that puts much less, that's much less overhead, that's a much lower lift on the lawyers advising the parties when it comes to ensuring that privilege is understood and then later on respected. So again, I push back against this sort of domicile idea.
We'll first take your question, then we'll go.
Thank you very much for the wonderful presentation. I think mine is just maybe more of a quick intervention as against a question. I've had to recently deal with a practical experience where someone who had read something about me online got in touch in the US to say he was looking to do something in my jurisdiction, Nigeria. And the issues that the person raised touched on international private law, conflict of law. And when the issue came to me, the first question I said was, remember, I'm not a US qualified attorney. My primary jurisdiction is in Nigeria. So for the US element of what you're trying to do, you need to look for a New York lawyer to advise you on that because they have that obligation. But for the Nigerian element, you know, which is my primary jurisdiction of practice, I'm very much akin to advise on that and also to advise on the international private law aspect of what you're dealing with. And the reason why that came up was that the moment I saw that email, there was more or less a red flag that says, if you cross this line, you will pretty much be practicing New York law indirectly, which ideally you're not even licensed to do. So my primary obligation, which I want to agree more with the territorial aspect of your presentation, is every lawyer would think from the angle of the jurisdiction from which they practice and from which they are barred. And that is what will influence as to what privilege you place on any communication you receive from a client. Thank you.
So let me take a different view. I sitting on a tribunal, I wouldn't view this as a conflicts of law question. In my view, the reason the forum rule applies, and it applies by courts, is that when you're when you're before a tribunal, the tribunal, and of course, privilege means exclusion. You're excluding communications, whether written or oral, from discovery or from production. And so you're taking out of the domain of the tribunal, the trier of fact, some information. I think the forum rule is often used, whether correctly or not, because I think a trier of fact or a tribunal does not want to consider certain kinds of evidence from one party and not from another. And think about it, whether a jurisdiction believes in the privilege or not, you can easily, I think, suppose that some of the most sensitive communications that a party has are between the party and his or her legal advisor. And so I think tribunals act the way they do and use the most favorable nation principle, or although one could use the least favorable nation principle, I guess, as well, not because they're worried about the enforceability of the award, I think it's to really instill confidence in the parties before them that they're going to hear the same kind of evidence from both sides, and that one will not be advantaged or disadvantaged, whether that's perfectly legal in their home jurisdictions or not, by virtue of the fact that there are different rules in play with respect to privilege. And so I understand what they do, and I think I would be inclined to do it myself, because even as a decision maker, I really don't think I want to know what the communications are between client and counsel on one side of the table and not from the other side of the table. I think it's going to impact me, one way or another. And so this is a very practical, pragmatic view. I will admit to you it's not principled, but I think it's how many tribunals view the issue.
I think there's a lot to be said for what you've laid out. I want to just tease out a couple of different points, if I may. The first is, I think if what you'll say, if the position is that for those very clear and good practical reasons, you're going to apply the most favoured approach or an equal approach between the parties, that feels to me slightly different from applying forum law. And I think you apply forum law, and the forum may well be chosen simply because it is independent and different. They've chosen London, and it's a Chinese and Uzbekistani party. And they've chosen London because it's not China or Uzbekistan. Or they've chosen Singapore because it's not China or Uzbekistan. Now, that would seem to be quite a random way to draw the line. And I see the sort of, I don't want to see, I want to see from you as much as I see from you, but that seems a random way to draw the line. I'm not sure that in reality there is a disadvantage to a party if they've communicated on the basis that these are open communications or not protected by privilege, to have those revealed. I don't think you're going to get a massive amount from that if you're following the rule I've set out. I can see the practical reality that for appearance's sake, use the most favoured approach. But again, that most favoured approach only comes after you've decided what choice of law rule to apply to determine the relevant rule. So you need to choose: is it the domicile of the party? Is it where the lawyer is barred? Is it where the communication occurred? You choose that, and then you apply the most favoured nation approach. But I think you've got to have a principled reason for that first step, and then I think that practical rationale for most favoured nation I think there's good sense in it. I don't think it has I'm not convinced it's principled, but that doesn't mean it's wrong.
Well, so we stay on time. I want to thank Paola, Jonathan, and Brian, and the audience for your attention.
So we have a 10 minutes break, and then we have one more session on corruption.
Thank you very much, Franco, and thank you for being here. Sorry, closer? Thank you. So thank you for being here, and I'm very grateful for the invitation and my stay here in New York at NYU in general, and also delighted to discover this format of seminar, of colloquium, which is extremely interesting. Corruption is a very broad topic. You can look at it from very different angles and perspectives. Regardless of which angle you take, it's delicate in all circumstances, because we know that any association between corruption and arbitration can be detrimental for the integrity and the legitimacy of arbitration and the confidence in arbitration. It was a point that was made earlier when we talked about integrity as such. This panel will focus on corruption allegations in international arbitration. A corruption allegation, as we know, is always a shockwave through a proceedings. When it is clear and obvious, you can focus on the consequences. of the corruption issue, but the fact is that that is seldom clear and obvious, and that is where the sharp minds need to be applied, and that's why we brought these two panelists, of course, trying to identify the best course of action, either as council or tribunal, becomes a very delicate exercise. Even as a tribunal, you've got to be quite careful what kind of questions that you ask. And when you ask the question, always ask yourself, what if the answer is yes, what do we do? It can be very, very delicate to proceed in that kind of proceedings. And so, as I said, it's like a fireball through the proceedings. And it's something that, surprisingly, I'm sure that corruption has been around ever since the date of time, but it became on everybody's radar some 7-8 years ago, I think. All of a sudden, it was there. And everybody had to take it into account, a bit like ESG today. All of a sudden, it's emerging, and it's no doubt here to stay, etc. And corruption, as I said, is the same all around the world, but what we will hear is that there are different approaches on how to establish corruption. We have two panelists for you with thought-provoking papers, and we have a debater. I will introduce the topics quickly. Ezequiel Vetuli will discuss uncovering corruption issues, when, why, and how are they relevant in investment arbitration. Ezequiel is an associate at Freshfields, in the Freshfields International Arbitration Group. You are based in New York. You are specialized in international law and arbitration with a focus on Latin America. You have acted in arbitration under all the major rules around the world. That is the ICC, ICSID, UNCITRAL, and SAPANI. No, I made that up. That's not true.
Soon.
He has represented many clients in different sectors. You joined Freshfield in 2016. You apparently spent 2 years at their London office, and now you are here in New York. Before that, you were in Buenos Aires. That is, in fact, where you obtained your law degree, and you obtained also an LLM from the University from Geneva, right? Matilda, or Maria, will discuss the view from under the table, how to prove corruption in international arbitration. Matilda is with Chavez, yes, since August 2019. Before you were in Paris with Curtis, I learned. You have vast experience in international commercial arbitration, commercial and investment disputes, again, under all the major arbitration rules, ICDR, ICC, UNCITRAL, in many sectors, specifically in the energy sector, construction, licensing, and distribution. And we also have, and you studied at McGill, in Canada, where you obtained your law degree and your JD, and you're admitted to the bar of New York. Today's debater or commentator will be Daniel Schimmel. You lead the arbitration practice of Foley Hoag's in New York. You're originally French, I understood. You obtained your law degree at the University of Paris 2, and then obtained an LLM and a JD at, I don't know if I can say it, at the other university. You have served as chair, sole arbitrator, co-arbitrator, emergency arbitrator, expedited arbitration, etc., in huge cases. Obviously, we know all that. And without further ado, let's start the discussions with Ezequiel, who will touch on the first topic. Thank you.
Sure. Thank you, Dirk. Good morning, everyone. I'm going to address the issue of corruption, or more broadly, illegalities in the context of investment arbitration. I thought I would start with the question of why this is a hot topic, following up on Dirk's introduction. I hope we can all agree corruption is bad. It has negative consequences across different aspects, being governance, democracy, the economy, and ultimately society. And virtually every country around the world condemns corruption in one way or the other. But the reality tells us that it is still a big issue around the world. There was a report by the IMF a couple of years ago that found that the annual cost of corruption was somewhere in the $2 trillion a year, which translates into something like 5% of the GDP globally, and that's certainly a lot. And foreign direct investment takes place in an environment where there is a significant risk for corruption. Why? We're talking about massive projects in the hundreds of billions of dollars where you have competing interests of commercial interests and political interests as well. You have the involvement of private companies and also the public sector and the government intervening in many different ways. So this creates a risk for corruption, and actually this is proven by the fact that if you take a look at the investment case law, you will find that it is full of precedents concerning corruption or other illegalities. So in those cases, when can corruption or illegalities become relevant? And I think that can happen in two different ways. One is when the corruption is used by the investor as a sword, right? When the investor invokes an illegality or corruption on the side of the state as part of its investment claim. So imagine an investor and the local authorities requesting payments, probably with no legal basis at all, under some sort of threat that if payments are not made, then something may happen to the project, something like delays in authorizations or the like. Well, in that situation, the investor may claim that conduct entails a breach of an investment treaty. And that has actually happened quite recently in a case, the case of Pawlowski v. the Czech Republic, where a similar situation where payments were requested and the tribunal found that such a conduct was a violation of the fair and equitable treatment under the applicable treaty. But more often than not, what we see is corruption or illegalities allegations being used or invoked more as a shield than as a sword, right? And that is when such allegations are made by the respondent state by way of defense, the state invoking the existence of corruption or illegalities on the side of the claimant investor. And so this could go to the jurisdiction of the tribunal, the admissibility of the claim, or even the merits of the claim. And I'm going to focus on this particular way of allegations of corruption because that's the one that has raised a lot of interesting legal questions. One first question is, well, which is the legal basis for an allegation of illegality to affect an investment claim? You may know we have a lot of investment treaties where you have what we call a legality requirement. That is a clause in the treaty that states that provides that the investment has to be made in accordance with the laws of the host state. 2 points to flag here. One is that those clauses usually refer or focus more on the making or establishment of the investment at an initial stage, and not so much on the subsequent life of the investment. And the second one is that those clauses are typically anchored in the domestic law of the host state rather than with reference to other more general principles of international law. Now, It also happens that we have a universe, a big universe of other treaties where you do not have such clauses, so you don't have a legality requirement. And there's a principle of treaty interpretation by which tribunals should not add any requirements which are not expressly in the treaty. So what happens in that situation? What happens if you have an investor that has committed an illegality, but then you go to the checklist of the treaty and you see, well, definition of investment, every kind of asset, definition of investor, nationality, all checked, 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 and then can that investor that meets all the requirements rely on the protections of that treaty? It's a tricky question, and the answer for the most part has been no. The investor cannot, an investor who has committed an illegality cannot rely on the protections of the treaty. However, there's no uniform position in how to reach that conclusion, and tribunals have taken different approach. Some of them focusing or just saying that every treaty should contain some sort of implied legality requirement. Others saying or focusing on the general principle of good faith. Others referring to transnational public policy. And others more specifically invoking the common law doctrine of the clean hands doctrine. I like the way a recent tribunal put it in the Bank Melli v. the Baharian case quite recently, where the tribunal said, well, it doesn't really matter the label. It found comfort in the fact that there is a consistent line of case law, and there seems to be a great degree of agreement that an investor cannot rely on a treaty in those circumstances. I do agree with this approach, but I think tribunals should be cautious when applying, especially principles which are not in the treaty. And I think tribunals should consider this as an avenue of exception and be careful when applying this on a case-by-case basis. And I think tribunals have done that, and that takes to other 2 points, which is tribunals have developed a series of requirements for an allegation of illegality to affect an investment claim. One first question is, will any illegality affect an investment claim? If you see the cases, you'll see a lot of examples from procurement of public contracts through bribery, fraud, the use of misleading or false information, the use of forged documents, non-compliance with regulations, overprices, and the list just continues. Is it all the same? Well, tribunals have said, and I agree, that it is not the same. And tribunals have said that only serious illegalities, and not trivial illegalities, only those that affect, really taint the investment can affect an investment claim. Imagine, for instance, a concession contract that was procured with bribery. That investment in itself from the very first stage is tainted by the illegality. That investment would not have existed but for that illegality. And so the essence, the very nature of the investment, its legitimacy as well, is affected. But is it the same when you have, during the life of a long-term investment, when you have regulatory non-compliance of specific regulations? Is it the same? Sometimes you see this question being discussed in cases, and tribunals have said that it is not the same. It is not the same. And I agree. I mean, of course, how you draw the line really depends on the facts of a specific case. But I think the distinction makes sense because those, to take the example of non-compliance with the regulations, I mean, those situations, I mean, the legitimacy of the investment is not affected, really. And probably there's actually I mean, the state has no interest in shutting down the business. Quite to the contrary, the objective is to fix the situation. And that can be done in a proportionate manner, for instance, by imposing sanctions, imposing fines, or similar mechanisms. And a second question is, what happens? The fact that there is an illegality does not mean that there is no breach of the treaty, right? So is it fair for a state to benefit, to get away with the breach of the treaty only because there was an illegality on the side of the investor? Even more, imagine a case of corruption where you have public officials that took part in the corruption. Is it fair for the state to benefit from its own illegal acts? I think the answer should be no, and tribunals have come up with some certain requirements to mitigate this situation as well. Basically, tribunals have said that a state cannot invoke an illegality when it has knowing the existence of the illegality, it has taken no action, it has overlooked that illegality. Or in other words, the objective is that the respondent state prosecutes, investigates such an illegality. And I think this requirement makes sense because it kind of goes to the previous points that I discussed, the seriousness of the allegations, the importance for the state, the consequences under domestic law. And also how the state feels about those illegalities, right? And the objective here is to basically avoid opportunism and avoid the possibility of a state fabricating ex post facto investigations only to stop an investment claim. And that is why the timing of those investigations is also very important, right? They should normally take place before an arbitration's launch, because if it happens during the arbitration, then you may get a bit suspicious. So in conclusion, I think to a large degree there is some consensus in the case law as to the relevance of corruption and the need to limit the abuse on the side of the states, on the investors. But at the same time, tribunals have tried to strike a balance and develop a criteria to avoid opportunism on the side of the states. Of course, in the end, it depends on the specifics of each case. And there's no uniform rule on how or approach on how to get there. But I think for the most part, there is some degree of uniformity. I think that touches upon the key points of the case law nowadays, and I look forward to questions or the debate. Thank you.
Thank you. Good morning, everyone. It is a pleasure to be here, and thank you to the organizers.
You have to get a little closer to the microphone.
Is it better? So we just heard Ezequiel present on corruption as part of the parties' claims in international arbitration, and I will now focus on how the parties go about proving such allegations of corruption, and more importantly, how these evidentiary issues are addressed by international arbitration tribunals. And there are two key issues concerning proof of corruption. First is the burden of proof, which seeks to define which party has to prove what in order for its case to prevail. And then a related concept, which is the standard of proof, that is focused instead on the threshold or the degree of evidence that is needed to establish a case or the particular facts of a case. So starting with burden of proof, the general rule is that each party has the burden of proving the facts on which it relies, and this has even been codified in some of the arbitration rules, such as the UNCITRAL arbitration rules. However, in cases involving allegations of corruption, some tribunals have departed from this approach and instead have shifted the burden of proof to the party seeking to disprove corruption once the accusing party has shown some prima facie evidence of the existence of corruption. And the reasoning for this is that corruption is often very difficult to prove, and so they say innocent parties should be capable of producing countervailing evidence. It is important to point out that the burden shifting approach never occurs at the outset, but only after the alleging party has provided some prima facie evidence of corruption. And tribunals often specify that this burden shifting approach is really only used in exceptional circumstances, in special circumstances, and for very good reasons. On the other hand, there have been some tribunals that have criticized this burden shifting approach. In particular, the tribunal in SIAG versus Egypt held that the reversal of burden of proof may make it almost impossible for the allegedly fraudulent party to defend itself, thus violating due process standards. And so on this point, the tribunal in Apotex versus United States made an interesting distinction between what is the legal burden of proof and what is the evidentiary burden of proof. So the evidentiary burden of proof is the obligation of either party to produce evidence, and the tribunal explained that while the burden of proof to produce evidence can shift between one party and another, depending on the state of the evidence, the legal burden of proof never shifts. And to me, this approach seems appropriate and circles back to the general principle with which we started, that each party bears the burden of proof to prove the facts upon which it relies. It does not mean, however, that a party can simply deny an allegation without more and throw the burden of proof to the other side, without, of course, running the risk of the tribunal finding or drawing an adverse inference against them. So now moving on to the second issue, standard of proof. Again, we have a general principle that is used in most international arbitrations, which is the standard of balance of probabilities, which is consistent with the common law standard used mostly in civil lawsuits. But the question of whether to impose a higher or a stricter standard of proof has also been debated. For example, some have proposed that in cases of dealing with corruption allegations, the standard should be the standard of proof beyond a reasonable doubt, which is used in more criminal cases, or an intermediate standard, such as the standard of clear and convincing evidence. And both of these standards have been actually used by international arbitration tribunals from time to time. Just to give a few examples, in EDF versus Romania, the tribunal held that because the accusations of corruption involved officials at the highest level of the Romanian government, it demanded clear and convincing evidence. And similarly, there have been a number of commercial arbitrations that have applied a beyond doubt or beyond reasonable doubt standard of proof when dealing with corruption allegations. But applying this stricter standard of proof has also been criticized by commentators and by other ICSID tribunals. And I find interesting what the tribunal in the Frappert versus Philippines said when this proposition was brought forward. And they basically said the jurisdictional question before this tribunal, which is seized of an international investment dispute, is not the determination of a crime. We really are here to determine whether an economic transaction constitutes an investment for the purposes of the BIT. And so really a standard of beyond reasonable doubt should be inappropriate to apply in these cases. And this is in line with what some commentators have said, for example, that the application of a higher standard of proof is unjustified because arbitrators do not have the power to send the parties or the party representatives to jail, for instance, or just more generally, international arbitration is not a criminal court, and it does not have the means to compel testimony or evidence in the same way that criminal courts do. And so finally, some remarks from the Rumpetrol versus Romania case. There, the tribunal said that in international arbitration, the rules of evidence are neither rigid nor technical, and so tribunals have a large measure of discretion over how the relevant facts are to be proved, alluding to the principle that tribunals have broad discretion in determining these issues, including when dealing with allegations of corruption. And so having looked at the burden and standard of proof, I will now briefly touch on the issue of what type of evidence suffices to prove an allegation of corruption, because it's very rarely the case that an allegation of corruption is proved by direct evidence or testimony or an admission. It really, it's really mostly through circumstantial evidence. So just a quick remark before we move on, circumstantial evidence does not mean a lower standard of proof. I think, and because some commentators have sort of criticized that approach, but I think this is conflating two different issues. One is the standard of proof, and the other one is the probative value of the circumstantial evidence that we're dealing with. And so in international arbitration, this circumstantial evidence has frequently been referred to as red flags. And in fact, the ICC has come out with a guidelines on agents, intermediaries, and other third parties. And they have created a non-exhaustive list of red flags for tribunals to assess when dealing with allegations of corruption. So I'm not going to go through the full list, but I'll give you a few examples just to give you an idea. For example, a red flag can be if the third party has a close personal or family relationship or business relationship with a public official or relative of an official. If the due diligence reveals that the third party is a shell company or has some other non-transparent corporate structure, or if the third party's commission or fee seems disproportionate in relation to the services rendered. And while these are not indicative of corruption in and of themselves, they are indicative of corruption by means of constituting circumstantial evidence. They are not conclusive evidence that a corrupt payment has been made or offered. But tribunals do rely often on these red flags, and there have been findings of corruption in international arbitration relying on an aggregate of the circumstantial evidence provided. Just to conclude, as we saw, there is really no consistency in international arbitration, either in the burden of proof or in the standard of proof. We have the two general principles, one, that each party bears the burden to prove the facts upon which it relies, and the balance of probabilities, which is the most widely used standard. But in the case of corruption, tribunals have departed from those rules, sometimes alluding to the discretion that they have, or claiming that claims of corruption are very serious and touch upon delicate issues, so they need to be scrutinized a bit further. And particularly in the case of commercial arbitration, sometimes the applicable law may automatically lead to a departure of these principles in a number of cases, because it could be that the applicable law does provide for a different standard or a different burden of proof. So that's where we are. And now I turn to Daniel. Thank you.
Thank you, and thank you for the invitation to speak today. I agree that allegations of corruptions have made a major appearance in commercial arbitration in the past 10, 20 years. And it's, I think, a sign of a larger development. The U.S. Foreign Corrupt Practices Act was enacted in 1977, and in the first 22 years of the act, there were in total 39 enforcement actions by the U.S. Department of Justice. So 22 years, 39 actions. In the past 2 years, there were roughly 30 enforcement actions by the U.S. Department of Justice. And we see in parallel that it has an effect in international arbitration proceedings, because many of them now involve, as part of the factual allegations, allegations of corruption or allegations of illegality. And they raise fascinating questions about the merits. And in particular, I think they raise issues of burden and standard of proof. That's one. They raise a question of how do you prove corruption or illegality. And they raise the question of what should a tribunal do? What should be the role of a tribunal? And it's an area where, you said it, Mathilde and everybody, it's very hard to prove. Because there's almost no direct evidence of corruption. I worked on FCPA investigations. I remember one individual who, when we presented with emails showing that an intermediary had been used and most likely to pay bribes, acknowledged that the individual was hired to pay bribes. People don't acknowledge that, and for very good reason, because if they do, the next step is probably that they will get fired. So you're left with, how do you prove corruption? So the first point I would make, and I agree with Mathilde, when a party, and I focus really on commercial arbitration because that's my my life, part of it. When a party raises corruption in an arbitration, there are three problems that party faces, right? One is the standard of proof, because very likely tribunals will set a very high standard of proof. And there are multiple examples in commercial arbitration, whether it's clear and convincing evidence or whether it's intimate conviction for tribunals that operate under civil law. They will set usually a high standard of proof, and many of them, at least historically, rule that the evidence adduced was not sufficient to meet that standard. So that's, you know, roadblock number one. Roadblock number two is document disclosure, because these arbitrations, when you think of a consultancy agreement between a company and a consultant, nobody in their right mind would put New York as a seat of arbitration for something like this, right? They put Geneva as a seat, and you know, sometimes they do it because Switzerland has bank secrecy laws, or because that's the place where the agent was supposed to be paid. But typically, these contracts don't have a seat of arbitration that involves extensive discovery. And so you have an issue of, you have a high standard of proof, and you have difficulty of proving it because you won't get a lot of document and evidence. And the third one is culture. And I think this is evolving because the US has been really good at exporting its model of deferred prosecution agreement and its model of proving corruption and illegality through red flags. And you see that a number of countries, including France, where I originally come from, but more than 30 years ago, a number of countries have adopted also statutes that allow deferred prosecution agreements. So culturally, things are changing. But what I believe historically, and I've seen, is that you had, for a long time, a cultural clash between lawyers who came from a jurisdiction like this, where we feel very intimately that if a company, if a client faces an investigation, that client must cooperate, and that client must admit facts. And now that client must make a voluntary disclosure even before there is any kind of investigation. And we operate, we understand and live with red flags. For a long time, I think that was less true in some civil law countries, and some civil law lawyers were reluctant to accept the idea that red flags would be sufficient to prove corruption or illegality. And lawyers and arbitrators also, I feel, for a long time, used to see these cases not as a case that arises from an FCPA investigation, but to see these cases as a purely contractual case. In other words, did the consultant help the company procure the business? If the answer is yes, is there clear and convincing evidence of illegality, of corruption? No, then the consultant should be paid. The framework was not looking at it through the lens of an FCPA investigation. So there there are these three things: cultural issues, amount of document disclosure, and standard of proof that were roadblocks. So as Mathilde said, a number of tribunals, as a response, have lowered the burden of proof or shifted the burden of proof, and that's one way of doing it. Other tribunals have said, yes, you can rely on red flags and circumstantial evidence, and I think this is the trend. And there's also another approach, which is to, if you can't agree on the existence or not of corruption, you can look at the contract and the compliance obligations under the contract. And this is, you know, a little bit what Ezekiel was saying, but in the commercial arena, you look at whether the contract includes strong compliance obligations, right? Obligations to maintain records, obligation to show the services that you provided, obligation to create reports. And you look at whether the company that hired the consultant actually requested those reports and asked for preservation of records. And if both things are met, you have tribunals that have said, well, okay, the consultant has not demonstrated that it satisfied its obligation. So in other words, that it is entitled to payment. So that's another way that tribunals, and sometimes as a compromise, have addressed these issues. There's, you know, one case that I want to talk about because it's very dear to me, and as a matter of disclosure, I chaired that tribunal, so I drafted part of the award, and it's now public on Jus Mundi. So I'm happy that it's no longer sort of a personal diary thing, but can be shared. This is a case that shows, to me, the flexibility of arbitration and why we practice in a field that is an amazing field. And we are not bound by sets of procedures of, you know, the countries in which we live. The case is called Alpha versus Heinemann. And my co-arbitrators are two Israeli arbitrators, Zvi Bar Natan and Eyal Rozovsky, who are both amazing arbitrators. The facts, the basic facts of the case are as follows. They take place in Israel. The Israeli government launched a very big public tender for the duty-free concession at the Tel Aviv airport. And it's one of the largest public tenders that Israel had. And you ended up having two bidders, more who could have made a bid, but two who actually made a bid. One joint bid by a company called Alpha and a company called Heinemann. Alpha is a Luxembourg company controlled by a business person who does a lot of work in Israel. And Heinemann is a well-respected expert in duty-free that has operated in this area for generations. So they got together and decided to make a joint bid. And then the other bid was by the incumbent, who had been in place for many, many years, and for which it was vital to keep that concession. And the two amounts of the bids, the Israeli authorities were only interested in number, right? The actual concession, annual concession fee. So they were focused on one data point, and on the day the bids were submitted, the Alpha Heinemann bid was about 167 million. And the JR bid was 169 million. So Alpha Heinemann lost by very, very little. And Alpha was, you know, uncomfortable, in part because they had learned that a few weeks before the submission of bids, there had been a meeting between senior Heinemann officials and senior officials of JR, right, the incumbent. And Alpha learned about it just before the meeting, but was told this is just an introductory meeting. We are not going to speak about Israel at all. It's very common for companies in the duty-free industry to meet, and so you shouldn't be worried about it. And there were several other things that Alpha was concerned about, but they didn't bring an arbitration at that point. That was 2013, the day, the year the bids were submitted. They brought the arbitration in 2018 when there was a public announcement that Heinemann and JR were now going to operate the concession together. And they brought an ICC arbitration with a seat in Tel Aviv and under Israeli law. And so first point, the standard of proof. Tribunals have discretion in what standard of proof they adopt, and for a number of reasons, in that particular case, the tribunal decided that Israeli standards of proof would apply, and in part because both sides had cited Israeli case law on the topic. And there's a whole discussion of burden of proof in the ORD, but basically the Israeli standard of proof is preponderance of the evidence. But when you allege quasi-criminal conduct or fraud, then the amount and quality of the evidence has to be higher. And the Israeli courts have said the party that bears the burden of proof and alleges quasi-criminal conduct needs to come up with greater and heavier evidence than in a standard civil case. And some cases there have said the single logical conclusion should be illegality when as what you need to prove. And the tribunal found that that standard was satisfied. There are two things. I mentioned before that one of the fascinating points is the flexibility of arbitration, what flexibility parties and arbitrators have. And in that particular arbitration, there are two things that the tribunal did. The first one was to appoint a tribunal-appointed expert who was an e-discovery expert. And the tribunal did this at the request of the claimant. And because there was, you all know what a Redfern process is. There was a Redfern process. There was a document disclosure order. There were a lot of questions asked about how reliable the document production was. And as a result, at some point in time, and after asking questions, the tribunal decided that it makes sense to appoint a tribunal-appointed expert to try to see if Heinemann had really produced the document that it was supposed to produce, and if there was a way to recover things that had been deleted. And we did it under the ICC rules and IBA rules because they both provide the flexibility to do this. We did it with terms of reference. We did it with guarantees of due process, which is tricky because it involves looking at the documents of a party that the other party cannot look at until they're produced. So it took some organization. It also it takes, when you do this, an enormous commitment on the part of the tribunal because it means that the parties will have to agree on search terms to look for documents, which means that the tribunal will have to rule on search terms. And as a lawyer, litigator in the U.S., you know, I heard many judges say, if you can't agree on search terms, I'll give you search terms. But in this particular case, the tribunal ended up having to look at search terms and make rulings. And then what it means also is that the tribunal needs to engage in sampling, right? And what that means is that the parties will, with the help of the expert, identify a body of documents that have the search terms. That party will then re-review them, but the tribunal then can do sampling, and in this case did sampling of a few hundred documents to see if it was satisfied. So it requires on the part of the tribunal a significant commitment and effort. But the award shows that there are a number of documents listed in the award that were not initially produced and that were relevant to the analysis of circumstantial evidence. So that's one thing that the tribunal did. The other thing that the tribunal did was to ask for specific documents, to ask for phone records between Heinemann and JR, certain phone records, and that involved the assistance of the Israeli courts, and to obtain the records from the operators. And we had the extraordinary cooperation of the Israeli courts, and what these records showed when we got them, is that there was a phone conversation between some of the most senior, very senior Heinemann person, and a very, very senior person at GR, very soon before the bids were submitted. And that conflicted with the witness statements of people who said that these communications did not occur, and they could not explain what was said or recall what was said in those conversations. And so when the tribunal looked at the evidence as a whole and how each item of evidence fit with the rest, it found that they had discussed the bids prior to the submission. And so just in conclusion is to say that to me, this example in this case shows the flexibility of arbitration, and that you can, in a particular case, and depending on the circumstances and what makes sense for that particular case, you can actually be very flexible in arbitration to get to the right result. And the last point that I will say is that that award, it's a super long award, but it also touches on the issues of privilege and what do you do with documents presented to you in a sort of non-traditional way that we heard about this morning. Thank you.
Thank you very much, Daniel, for sharing that. The floor is open. Yes.
Ezekiel, I have a question. So what happens if the arbitrator now is convinced that there was corruption? Because I think the point you made is, of course, correct. Corruption requires two parties. I mean, clearly, in this case, the cases you refer to, the investor on the one hand, and of course, a representative of the defendant. What should the arbitrator do when corruption is proved? I've seen arbitral awards that deal with the issue as an issue of admissibility. I'm not sure whether that's an issue of admissibility. But what should the arbitrator do at the back end, meaning once the award is to be rendered? There's one case that's very interesting. The arbitrator decides there was corruption. Yes, the money requested, claimed by the claimant was actually, the damages was actually to be paid out to a non-profit organization. In that specific case, I think it was the Red Cross. I think it's a nice solution. None of them earned something because it is good for none of them to earn something in a case where both were involved in the corruption. What would you say to that?
Oh, thank you, Franco. First, on the question on whether it is a jurisdiction or admissibility question, briefly what tribunals have said is that basically it depends on whether it is related to the initial investment, in which case it would affect the jurisdiction of the tribunal, whereas in cases where the illegality is related to the life of the investment, it is an issue of admissibility of the claim or on the merits. I think that case is very, very interesting. For sure, I mean, the involvement of the state in the act of corruption, I think, must be factored in. And I think that approach was interesting. Another way in which, I think it happened in that case, but also in other cases, what tribunals can do is also take that into account when they allocate the cost of the arbitration. Because they can also say, I mean, it goes to whether there was a legitimate claim, right? So if both parties were involved in the, I mean, it takes two to tango, right? So if both parties were involved, then there must be, or there could be, some legitimate claim or potential claim on the side of the investor. It is not. It would depend on the case, but I would assume it is not crystal clear that there was an act of illegality on the side of the investor, and that sometimes relates to the fact, as Daniel was saying, that sometimes corruption is not that clearly cut, right? And so maybe the act of corruption. I don't want to say that the investor is sometimes induced to engage in the corruption, but it could happen that the investor is not that clear as to whether what it is doing is an illegality or will turn out to be considered an illegality by a tribunal. And on that point, I think that one of the recommendations is always to do a good due diligence when they establish the investment, especially when in the making of the investment there are third parties involved. But the concrete answer is I think that approach was very creative, very interesting. I'm not sure whether payment was made in the end, but I think that was interesting.
Thank you. Diego?
Yeah, I have two concrete questions raised in real cases, and maybe for Ezequiel, but I think both of you can answer the question. The first one is, Ezequiel mentioned the issue of the difference to local courts' decisions or investigations on corruption. And I don't know if you are aware of the new treaty between Colombia and Venezuela, but in that treaty it appears as an obligation for the arbitral tribunals to follow the local determination of corruption. And I would like to know your opinion on that. In particular, in a real case, there is the investigation started before the case was initiated, the arbitration was initiated, but this is still ongoing. So the case was initiated several years ago, and according to the respondent, the arbitral tribunal must not decide, so that there is a risk for the arbitral tribunal to decide that there is no corruption because it is likely to happen that in some years, maybe next year, maybe in 3 years, the local courts will determine that there was corruption, so that all the investment was tied by corruption. So I would like to know how one would deal with this kind of situation. And the second question also is, what happens, and you didn't mention that in your presentation, which I found really interesting and quite complete on the topic, is what happens if there is a consortium of companies obtaining a concession, and one of the companies, and that is a real, but has been happened in several cases, and one of the companies not only is pursued by corruption, but has acknowledged corruption. But the case is advanced for another company. So I say, well, that was my partner, not me. And there is no proof, no evidence against me. And so I have the right to have a compensation, for example, for the termination of the contract. And the respondent said, no, all the operation is not about corruption. It's not only one of the partners of all the operation. And it's a tricky issue because the the claimant said, well, there is no evidence against me, so you are applying a kind of objective responsibility, and I am just asking for what I put in this business. If my partner was corrupted, it's not my fault. So I think, I know that there are two difficult questions, but I would like to know.
Sure. Yeah. Thank you. I'll try to be brief. On the new treaty, I focus my practice in Latin America, so I've heard of it. I find it very, very interesting, that treaty between Colombia and Venezuela, in the way it goes about several points, but specifically on corruption, which is linked to the, if I'm not mistaken, the denial of benefits clause. In my opinion, that drafting technique goes a bit too far, because it gives a lot of discretion to the state to make a unilateral determination of the existence of corruption, even at an administrative level. I encourage you to give it a read, because it's quite interesting. So I think, in my view, that is probably a step too many in the fight against corruption. On the issue of ongoing proceedings, I think that's a very interesting one, and it relates to the issue of timing, right? First, when the prosecution or investigations are launched locally, but also when you have a decision. I think first it goes to the credibility of the proceedings, if they were launched before or after the fact of the arbitration is launched. And then on the decision, I think the position, there's no uniformity, but I mean, generally, investment tribunals will have some deference to the decision of the local authorities, and it could very well happen when there is a decision on corruption or related issues. But also, I think they are not bound by those decisions. And there's an interesting case that it's a saga of different decisions, and there was a recent decision by the courts in Geneva, I think a couple of weeks ago, where basically the court that was reviewing an award, an ancestral award, said basically the local courts, criminal courts, had reached a decision on finding corruption, and the tribunal had previously said that it did not find corruption. And so the state sought to review the award, basically alleging, well, now we have a decision, and the Supreme Court of Switzerland found that there was corruption. And the courts in Geneva said, well, that does not necessarily affect the award. So I think the answer is, it is important to take into account the decisions that you have locally, and they can shed some light on the issue, but tribunals are not necessarily bound by those decisions. And then finally, on the question of the consortium, I think that's a tricky one. I would say the same happens, and it has happened to me in cases where what you have is different shareholders, right? And the shareholders may have different involvement in the alleged illegality. To me, the analysis, I'm not aware of concrete precedents setting a rule on this, but I think based on the principles that the case law has established, what matters is first look at the conduct of that specific investor that is bringing the claim, and then go through the criteria that has been established by the case law. And then I think most likely when you go through each of those elements, it may become relevant, the fact that others were involved in corruption. So probably it goes to the knowledge, right? Because the knowledge is not necessarily objective, but also, again, going back to what I said earlier with Franco's question, there must be some due diligence. So the question would be, this shareholder or this company in the consortium did not know, but should have known. And I think, I mean, the answer will depend on the specific case, but I think that would be the standard that a tribunal should apply.
Wow. We have no more time? Okay, we have to close. Thank you, Mathilde, Ezekiel, and Daniel, for your presentation.
So allow me just to thank all of the speakers, all of the debaters, and of course the moderators for coming today, some from afar, I have to say, to discuss this. This is the third IGAS. It's the first one, however, in person. As we planned from the beginning, meaning Professor Diego Arroyo and I, is to have a section here and then one in Paris, so we alternate. The next one will take place in Paris at a time yet to be identified. I hope that some of the graduate students who are in the room will be able then to present their papers at the next one. So thank you very much and hope to see you soon.